and described as they come to be identified as the most backward class of citizens we have in our country. This is a run-up to reading 5 paragraphs earlier, my lord. I could give your lordships immediately, starting from 124, and this is 165. All these paragraphs, my lord, are devoted to this. Expressions, they are in they are the lowliest, they are the backward of the most backward, and then to culminate to say they are the most backward. In the face of this, for the state to say that we have identified this, no, I would say it's not available to them. They are arguing against N.M. Thomas when they say so. This is the most backward. 169. Kindly turn to one other paragraph, 169, a few paragraphs down. Thus, in view of these provisions, the members of.
You read para 167 also.
165 minute?
167.
167, very 167 minute. A combined reading of 46 and clause 24, 25 of 366, that's a definitional, clearly shows that the members of the scheduled caste and the scheduled tribe must be presumed to be backward class of citizens, particularly when the constitution gives the example of scheduled caste and scheduled tribe as being the weaker sections of the society. Constitutionally, my lord, 46 says so. Your lordships have seen it, my lord. 46 says so.
46 is also reproduced there, just in a paragraph above that.
Yes, my lord. The state shall promote special care, educational, economic interest, weaker section, in particular of the scheduled caste and scheduled tribe, and shall protect them from social injustice and all forms of exploitation. As a group, no segregation allowed. Whenever we talk of for the purposes of this constitution, look, these are the embargoes on them. What is being asked on the other side is, where is the bar? These are all bars. I have a separate heading of a bar. I'll place that also, my lord. Then 46, 167, and when my learned friend wanted me to read 169. Thus, in view of these provisions, the members of the scheduled caste and scheduled tribe have been given a special status in the constitution, and they constitute a class by themselves. That being positioned, it follows that they do not fall within the purview of 16(2) of the constitution, which prohibits discrimination between the members of the same caste. If therefore members of the scheduled caste and scheduled tribes are not caste, then it is open to the state to make reasonable classification in order to advance or lift these classes so that they may be able to properly represent the services under the state. Undoubtedly, this can be done under 16(1) of the constitution. Yes, plus please do it as such for the entirety of it. Please don't bifurcate. Why? Because they are the lowliest and they form a class by themselves. Binding on all of us, my lord. N.M. Thomas says it, and they are arguing right in the contrary to this. Give me that solutions. What this was read. Andhra, I want in item 4, my lord. I'm in the bullet point 3. Now I just need to touch one or two aspects, my lord. I think I have. In item 4 and the bullet point 3, the Andhra example is given that all these shades of ingenuity, if I may call it with the utmost respect, will come up. What is that ingenuity in Andhra now? Punjab experience, your lordship have seen. 76 is my total entry.
Out of which 7 have been clubbed together that year.
As one.
Tamil Nadu.
Tamil Nadu.
Tamil Nadu, actually, not Andhra.
Thank you.
That is, we'll have to correct that.
Lord, my mistake. Tamil Nadu, Lord. Lord, why? I was asking myself this question, why 7? Because it can be argued that they are a class by themselves. Because if I come 1-to-1, Balmiki and Mazhabi, I may be criticized of 16(2). This is the ingenuity which will come up. And that is exactly what Dr. Ambedkar said no to. We don't want political factors to come in. We don't want any disturbance in the list. N number of situations and ingenuities will come in. to factorize in that, no, we are not including, excluding. But Lord, as it fell from my Lord the Chief Justice's first day, that this is virtual exclusion. This is my virtual exclusion.
Not an exclusion.
I'm sorry, my Lord.
Among the reserve categories, only they have been given preference for 50% of the seats.
Yes, my Lord.
So you can also compete for the 50%.
For the
But-
balance 50%.
No.
Ah.
But no. You can even compete if suppose a sufficient number of candidates it's a preferential allotment.
Yes.
So it's not a quota which is exclusively reserved for these two posts.
Yes.
To these communities. In Tamil Nadu. No, so it's only a preferential allotment.
In Punjab, first
So,
preference.
sorry, Tamil Nadu it is there. I mean, in
Punjab.
Punjab, it
First
says
preference.
it's first preference.
Yes. Lord, kindly see me, Lord. To the extent of the first
So
preference.
according to you, among that category,
Yes.
the survival of the fittest has to be followed. Who are based among that category, irrespective of the relative degree of backwardness, they will get the post.
Lord, I'm
What has been done in percentages has been
Where?
in Andhra ABCD category, 7%, 1%, 1%. So, my lord, what we were getting earlier gets reduced, my lord. So that would be the factor, my lord. Apart from the other, this thing, my lord, whether the state has power or not, within my submissions, they don't have. I wanted to distinguish, my lord, Chinnaya with the other matter. The submission is, my lord, if your lordships read, my lord, 15.4 and 16.4, 15 exclusively deals with SC, ST, my lord, which words your lordship will not find in 16. To that extent, my lord, once it is a class as a whole, it is a class of weaker sections or uneducated or lowly income, my lord. It will not say, my lord, that scheduled caste or scheduled tribes.
But 15.4 also does not exclusively deal with the SCs and STs.
Education backward class of
Kindly
citizens
read-
or for scheduled caste and scheduled tribes.
Right.
It says
15.4
as 15.4 also uses the expression socially and educationally backward class.
backward within them, my lord.
No. Or for the scheduled caste and scheduled tribes.
Separately. Backward class, socially and educationally backward class of citizens or for the scheduled caste and scheduled tribes.
Right.
So 16.4 is actually broader than 15.4.
Broader, my lord.
Because 16.4 may include some backward classes which are not scheduled castes and scheduled tribes,
Right.
and strictly speaking cannot be regarded as socially and educationally backward classes of citizens.
In other words, it's being said, it's not exhaustive of the power.
That's all. So 16.4 may possibly be wider than
Said so,
15.4.
my lord, 803 of
That's
Indra
right.
Thani. Said so already, that it is wider. And the opening language of 16.4, nothing in this article shall
Right.
prevent. Those words were.
And the words is not adequately represented in the service under the state.
Lord, this brings me, my lord, if I lordships permit me a few moments further.
You would ought to take into consideration the word that is not adequately represented in the service under the state.
Not there, that the exercise of 16.4 is not adequately represented, is a prerogative they exercise.
So therefore,
Yes,
amongst that class, if the state finds that
not
a
adequate.
class among that class
Is not
is not adequately represented,
Yes.
whether it will be debarred from taking an affirmative action under 16.4 to remove those inequalities.
Lord, submission is 16.4 is indeed using that expression not adequately represented, but it is targeting what? The class as such.
According to you, when the state goes into underrepresentation, it must look into underrepresentation of the scheduled caste as a whole in that state, not that particular community within
If
the.
they do so, my lord, if they do so,
That will be
16.2, then they are doing so,
Contrary to
they will come out with an affirmative action by legislation or an executive order. If the state wants to address that situation, that we find that in this scheduled caste, we find that these people are eating away all the vacancies. They will have to come up with an affirmative action.
So to
If
put
they
it,
do
look at it like this. Suppose the state finds that, say, a caste which has hitherto been doing predominantly the occupation of manual scavenging, right? They are underrepresented in the services of the state.
Yes.
The state can't take any action. Why? Because if, as a whole, the scheduled castes are not underrepresented in the services of the state, then though there may be certain communities, I give you the classical example of those who are hitherto engaging in manual scavenging. State government then has no power because you have to look at the overall scheduled caste. You can look at the micro picture in relation to any of these castes.
And
But according to your caste is not a class. That's the argument.
if they do so, my lord, then it will be on the basis of a caste, which will fall on 16.2. That will be a classification on the basis of caste. This is one reason. Second reason, they have no role to play. They have played their role. Lord, answering 16.4, my lord, N block state they find unrepresented, then they will do so for the entire block, because any backward class of citizens, which will include SC, ST, OBCs and others, but as a class. It's not as if, as I submitted, the situation is remediless. Yes, there is a route, but state has no role, and they.
What is the route? According to you,
Yes, my lord.
you said that the words used is only add, include or exclude. You yourself argued that it is not permissible even to vary that.
It's certainly not. The route is this.
Therefore,
the route is this.
Again, I have to put it the same question. If
Yes.
the state finds that
Yes.
A caste has reached up to 75%, but not 100%,
Yes.
and D caste is only at 10%.
Yes, my lord.
So either exclude A, though it has not reached 100%, and continue with the others. Would it not be injurious to you if the state does that? Or if the state recommends the parliament to do that, and the parliament does that?
Probably the route is 342A3. Kindly read it.
Yes, my lord. The third part of it, yes. The state list. The state list.
State by law,
Yes, lordship.
notwithstanding anything.
342.3. 342A3.
342A3.
No, but that is only for
SCBC.
SCBC.
Right.
Yes.
That class can be included in.
No, but SCBC.
Duty has been cast to maintain.
Give me that. Three. Give me that 3.
Body act.
What yes, may I have?
Notwithstanding anything contained.
A3. Yes.
Notwithstanding-
Notwithstanding anything contained in 1 and 2. I'm reading 3, 4. I'm sorry.
Yeah, 342A3.
Yeah.
State has no power. Central list.
It will be different.
So see, my lord's question, lord, and then I just immediately thereafter read 342A also. My lord, this is Gawai's question. They find that this is the data, some one caste has gone up. Lord,
They don't say one caste has gone up. They say that these two castes
have been left behind.
have no representation at all.
Lord, kindly see.
Far behind.
Lord, kindly see the iniquitous situation. There is no assertion on record from
We are
the
not
state.
going to we are not going to the
That is-
sufficiency of the
that
data.
High Court will test or, yeah, because that
We have
point has
only to
not
see
been
whether
dealt.
they have the power or not.
Whether, you know,
just
they
forget.
had, whether they had collected data, whether
Yes.
they have data, what should be the threshold requirement, that we'll also lay down.
Yes.
Because it can't be that the states can just do it, everything at their whims and fancies.
Yes.
Obviously, the state is also duty bound because to act in accordance with the constitutional mandate, and they must have objective data, quantifiable data, as we have said. And that the High Court will test ultimately whether they have.
Just
fulfilled
formulate
that
this
or
submission
not.
which I wanting to make. Mazhabi and Balmikis are taken up by this. Lord, is it to be accepted that none of these categories have advanced? There is an inherent
Again, you are
presumption.
going into the rationale of doing it.
That
Question
is
is
not
whether
the-
they have the
this is
power
not
or
the
not.
stage,
We are not
because-
going to the rationale.
Yes,
We are only.
We are
questioning
testing the correctness of
Chennai.
Chennai.
yes, my lord, yes, yes. Lord, I wanted to read 342A, my lord, and 3 thereof. And this is, of course, in the background of socially and educationally backward. Yes, my lord. 3 thereof. Nothing contained in clauses 1 and 2, every state or union territory may by law prepare, maintain for its own purpose a list of socially, educationally backward classes of entries to which may be different from the central list.
So it is presumed that SCs and STs are socially and educationally backward.
Yes.
They are the most backward class of the backward class. So that can also be done. This could be the route through which, if one finds that a particular caste is not being included, has not been included. So this could be included by way of 344A3. Probably.
Lord, each of them, each of these categories in 341, 42, 42A, they have a commission. Now we have a commission, a constitutional commission, which will advise and will send it, as I submitted, to the president. And there the fresh experience comes in. That's the route identified. They are trying to find a route in 16.4. 16.4 is only that you may give percentage of reservation. Yes, indeed so. It's a purpose. It's in part 3 that yes, nothing will prevent the state from making that provision. For that
You know,
purpose,
Mr. Saru, actually the constitution has used 3 expressions: backward class, scheduled castes and scheduled tribes, and socially and educationally backward classes of citizens. Though backward class will include the socially and educationally backward classes of citizens and scheduled castes and scheduled tribes,
yes, Lord.
perhaps the scheduled castes and scheduled tribes as a grouping cannot fall within the SEBC. They are very distinct.
They are distinct, Lord. No
Therefore, you know, apropos my sister's question, when the state is exercising the power under 342A3, they can't exclude the SCs and STs or any part of the part thereof in exercise of the power under 342A3. Because 15.4 clearly specifies the scheduled castes and scheduled tribes as a distinct conglomeration from socially and educationally backward classes of citizens.
Yes.
16.4 makes that very clear, that it says for the advancement of any socially and educationally backward classes of citizens or for the scheduled caste or scheduled tribes.
Yes.
If the scheduled castes and scheduled tribes were deemed to be a part of SEBC, there was no need to refer to them specifically in 15.4. But 16.4 is much broader. Therefore, it just says backward class, which will include the socially and educationally backward, the scheduled castes, the scheduled tribes, so on and so forth.
Indeed so.
And any other backward class as well.
And that expression any, my lord, in 16.4, when they say any backward class of citizens, again talk of class, not any member of that class.
That is the point really. That's the point which they have to meet actually.
Lord,
That
that
is
takes
first
me, my
to a
lord,
class.
if your lordships kindly permit, it is being said, Chennai, that takes me to point 5, my lord, that Chennaiya judgment is per incurium because it doesn't have a discussion on the interplay 341.1 and 16.4. That was argued, my lord.
Can you give us the paras of which in Chinaya, which
I've-
according to they discuss it?
I've given it immediately there, my lord. 31 and 50. Right in the heading, my lord, my lord, the Chief Justice has. In the heading 5,
Yes, yes. Oh, sorry, yes.
I'm sorry, my lord, it's there. In para 31 and 50.
So Chinaya does discuss the interrelationship.
Yes, my lord, it does. And it attributes the role, identification role, if I may summarize, if I paraphrase in my own way.
1 and 4.
Yes, Lord, in a moment, Lord. 796 of volume 5, Lord. Sorry. And at page, Lord, this is. Yes, Lord.
At page
At 798, Lord, my mistake. 798 of volume 5, Lord, PDF page.
let me just look at it quickly. Yes.
And this is the judgment, Justice Hegde's judgment in 31. What would be said is the content of 341 will be first considered. I'm sorry. Milord, 31 at PDF 798, Milord, of volume 5.
Between placidum E and F.
Yes, my lord. And above that is the content of 341. And below that, as my lord's is pointing out, my lord, is the consideration of 16.4. Can I place that, my lord?
Yes.
On a detailed perusal of the Act, it is seen that Section 3 is the only substantive provision in the Act. Rest of the provisions are only procedural. Section 3 of the Act provides for creation of 4 groups of the caste enumerated in the presidential list of the state. After regrouping, it provides for proportionate allotment of reservation already made in favor of the scheduled caste among the 4 groups. Beyond that, the Act does not provide for anything else, since the state has already allotted 15% of the total quota of the reservation available to the backward classes, for the backward classes to the scheduled caste. The question of allotting any reservation under this enactment to the backward classes does not arise. Therefore, it is clear that the purpose of the true intendment of the Act is only to first divide the castes in the presidential list of the scheduled caste into 4 groups, and then divide 15% of the reservation allotted to the scheduled caste as a class among them. This is clear that the Act does not for the first time provide for reservation of scheduled caste, but only intends to redistribute the reservation already made by subclassifying the scheduled caste, which is otherwise held to be a class by itself. And then, my lord, well settled principle in law that reservation to a backward class is not a constitutional mandate. It is the prerogative of the state concerned if they desire, with the object of providing opportunity of advancement in the society to.
Classification, in the classification, there was a sub-classification,
Yes, ma'am.
not on the basis of caste, but on the basis of the empirical data of not adequately being represented.
Yes, ma'am.
You know, how would it hit Article 16.2? And it is not a discrimination on the basis of a caste.
Lord, this is to submit, Lord, those were 4 groups made in Chennai case. The criticism on the other side was that 341 vis-a-vis 16.4 is not even, has not been considered, and therefore per incurium. To that, my lord, what I wanted to submit was that the content of 341 and the content of 340, the 16.4 has been considered by the Honorable Court in that bench in these 2 paragraphs.
Apropos what my learned brother said, 16.2 uses the expression only,
Only on the ground.
right?
Yes.
Therefore, if the positive discrimination, if you can call it that way, in favor of these 2 communities is made not on the basis of caste alone, but on an objective factor, namely underrepresentation, which is contemplated by 16.4, then it may not offend against 16.2.
But kindly look how the language of the statute is cast. The 4(5) of the Punjab Act. These 2 categories are picked up. These 2 castes are picked up, Mazhabi and Balmikis, and a legislation for that. So the target group, so to say, is the caste, which according to our submission is foul on 16.2.
If they fail on underrepresentation, then it's a discrimination on the ground of caste. But if they are right on underrepresentation, then it's not a discrimination on the basis of caste, because then it is based on objective criteria, namely the extent of the underrepresented.
I don't think there was no data when.
We are not going to that question
may
whether
be
there
right
is data
also,
or
that
not.
High Court will deal with that.
Whether there was a data or not, or whether the data was sufficient or not.
That was, I'm saying, when this was framed out. There was no such thing.
That, I mean, if you are right, the High Court will have to deal with that argument that you had no quantifiable data at all when you made that.
Lord, when
Like, it is-
Lord, this data also in the, your lordship would kindly
So sufficiency, insufficiency, existence, non-existence of data. The question is whether the state is powerless or not.
on the constitutional plane, I could submit, when when Thomas lays down as a law that they are a class by themselves and that they are the lowliest. Lord, then for the state to say otherwise is by submission
State
is
can
not
go-
available to them.
According to you, the state cannot go into the question of lowliest among the lowliest.
Lord, this is, they have reached the rock bottom. And also, Lord, kindly see, this is one side of the picture that fresh experience and there may be inequalities and we want to redress it. This is one part. There's another part that there may not be a political tinkering with this. And this is an all India feature now. We don't want a situation, the constitutional mandate, the constitutional
The
debate.
courts are there under Article 226. The courts can always examine whether the decision taken by them is on the basis of empirical data or not. It can always be found that as to whether the action proposed has a nexus with the object or not.
Lord, my submission is, Lord, why is this freezing exercise being done, if I may call it? Why is this freezing exercise being done? Why is this insulation exercise being done? To take away any aspect of political tinkering. The danger writ large, even at the time of framing, which your lordship, that passage has been seen. These are the two competing factors. Inequalities removal and the political tinkering. This has to be balanced. Therefore, the court is saying in Thomas that this is a class by itself. Now, how does the state enter into that class? In my respectful submission, they can't without doing violation too. It's a class by itself. It's a special class, to use two exact expressions in 165 of Thomas. They are the lowest rung. Now, where is the opportunity for the state to say, no, our experience is this, our legislation is this? No. Is my respectful submission, my lord.
And we will have to take into consideration the future possibility. Forget Punjab. Punjab doesn't make any reservation for scheduled tribe, a particular.
Yes, lord.
Other states may make for a particular scheduled tribe,
Yes,
particular scheduled caste.
yes.
That would be in exclusion of other scheduled castes and other tribes. So that may create a situation which may amount to discrimination amongst the members of the scheduled caste and scheduled tribes.
And scheduled caste, scheduled tribes, all taken to be the lowliest and to constitute a class. When held by Thomas, they want to pierce that. The entire effort is to pierce that. Lord Indra, Lord, I have one last of this first page in item 7. This Jayashri Patil, Lord, judgment said so, apropos my lord's question, that 342A brings in a new regime. 342A, those three articles which come in 2018, is being said in Jayashri. I could give the paragraph. The exact expression used is that it brings in a new regime. Vis-a-vis the Indrasani. It was compared. I could give that.
Yes.
Just give me a moment.
Yes. SC Patil is 1466.
Yes,
PDF.
Milord. Yes. At Milord PDF 1605, Milord. In paragraph 157, 158. Particularly 158. Volume 5, Milord, PDF 1605. These are the conclusions, Milord. I must first place that at 158. SCC page 140, Milord. 158 paragraph of SCC. The evolution from Indrasani, etc., all being noticed. 2018 noticed, select committee noticed, and then the culmination. This, can I place that note?
Yes.
at 158. This sequitur is only reason why changes are envisaged in the first place by the parliament, sitting in its constituent capacity, no less, which is to alter the entire regime by ensuring that the final say in the matter of identification of SCBCs would follow the same pattern as exists in relation to the most backward class of citizens, that is the SC and ST, through Article 338, 338A, 341, 342. Too much cannot be read into the expression centralist. That controversy your lordships have seen. That was redressed by bringing in centralist in 342A later on. That clarification came. And I could read one or two, Milord, conclusions in Patil, which are on the same page, Milord, at 156, in paragraph 156, just above, Milord. 156.2, the use of the expression means interpreted to imply exhaustive definitional expression. That expression used in 366, the definitional one. And then if your lordships just come a little further down, my lord, 156.5, the expression of the use of expression for the purpose of this constitution also emphasizes the idea that for all purposes under article this, only the communities or classes deemed to be SEBCs under 342A would be treated as such in relation to the state. And then this conclusion. Kindly see the end of 156, my lord. Paragraph 156, the last few expressions. These expressions are omitted and an entirely new provision exclusively for the purpose of socially and educationally backward classes are inserted. That is the Commission 338B, which independently consider all aspects relating to SEBCs in the manner identical to SC/STs. So it's a constitutional commission which will consider the entire data. If I can take a few moments on item 10 on the page next minute. But what we said is creamy layer, as if suggested creamy layer suggested is accepted norm in SC/ST. Lord, that is in the light of Nagraja and that is in the light of Karnell, which were promotional Jarnail Singh, which were 4A and 4B situations of 16, promotional, not at the entry point.
So according to you, that's what, because as Mr. Gopal Shankaran said, so far no government, including the central government, have issued any office memorandum that a creamy layer would be applicable to scheduled caste, scheduled tribe also.
Yes, Lord. Lord, none at all to our notice as well, none at all. But what is being suggested is that there, by the root of creamy layer, the class of SCs is available for dissection. Yes. Exactly. So, क्या मतलब होता है उसका But the suggestion on the other side, or the submission on the other side was, as if to say, and at one point, the state volunteered to say work in progress. When creamy layer was posed by the Honorable Court, the state government volunteered work in progress. That's the exact response, my lord. But when creamy layer is being suggested, what is being suggested is that when we can enter into the list, when we can bifurcate the list on the threshold of creamy layer, why can't it be done? That means it's pierceable. That means it is subdivisionable. That is being suggested, my lord. And in that aid, Indra Sani, Nagraja, Ashok Kumar, and Jarnail Singh are being cited. What I would submit is, my lord, Indra Sani specifically said when it was permitting classification backward and more backward, in paragraphs after paragraphs, that we are not talking of scheduled caste and scheduled tribes. Your lordships have seen that paragraphs. That's one. Nagraja is a promotional case. 16(4)(a), 4(b) for scheduled caste, scheduled tribes. So not at level 1, at level 2. We are at level 1 situation. So therefore, very different to talk of Nagaraja, very different to talk of Jarnail. Ashok Kumar Thakur, again Constitution Bench judgment, which is interspaced between the two, between the last two in item 10 of mine, between Nagaraja and Jarnail, Ashok Kumar Thakur comes, which is the validity of 15(5). Can make special provision for admission to educational institutions. The state can. So entry point, there they say no creamy layer. That's the correct position according to us.
So the persons from scheduled caste who are now in a much advantageous situation, they should also continue to get the benefits of scheduled caste.
Lord, those who are, my lord,
A
those
scheduled
who are
caste
in the
person,
position, your lordship say they will continue to get that benefit.
you are saying that no creamy layer. So a scheduled caste persons whose child takes education in say Shriram school or Sanskriti, and a person residing in some small village taking education in a Gram Panchayat school, he will compete with the son of a man who is taking education in the best of the schools in Delhi. This is what is meant by Article 14.
Lord, there has to be, Lord, I myself said there has to be a redressal if such situation comes. The route is there, but who is to address that situation is the question, Lord. Is the state to enter into it on the anvil of 16(4)?
So whether in last 75 years, whether a same family should get benefit of reservation on 4 occasions, 4 generations.
No, the answer emphatically has to be no, my Lord.
And the persons residing in the villages to perpetuate to live in those situations.
Lord, perhaps before even.
So that is not a question before us.
Yes, my Lord, yes, indeed.
But the question your lordship has asked, that has been answered already. That's why the reservation was given. Only it was objected.
What else, Mr. Swarup? Anything now?
Lord, I'll just, on the last two, Lord, on the last 2 points, if your lordships kindly permit, my Lord, very, very briefly. Lord, what was argued yesterday in the second half, later session was vertical and horizontal reservation. Lord, this doesn't qualify for intersectional. This is not intersectional reservation at all. It is not. This is item 12, my Lord, in bullet point number 1. This is subvertical reservation. Because your lordships know, my Lord, this is being dealt with in, if at all an authority was required, in para 812 of Indra Sani, that horizontal and vertical, how do they work? And when do we have horizontal? That the horizontal position he can occupy in any of the verticals. Now here the Mazhabi and the Valmikis are staking claim only against one vertical, that is the scheduled caste. So there's no question of intersectional here. A solution being found that intersectional can be considered in this case. But I would respectfully submit no, my lord. This is subvertical. And then that takes me to the last two, my lord. Where is the bar? It was repeatedly asked on the other side. Lord, my answers are these, my lord, these four answers. The bar is 16.2. Where is the bar to state and taking into this endeavor? The bar is 16.2. You are identifying on the basis of caste.
But 16.2 says only on the basis.
But 16.
Lord, kindly see the target. Lord, kindly see the target group.
And you know, there is of course,
Ah.
following Nargesh Mirza and that line of cases, I've also dealt with it in my judgment in Sabrimala. 16.2 at one stage, for instance, suppose you discriminate against women, right? For instance, you say that a married woman will not be entitled to continue as an air hostess.
Yes.
The argument was that this is not a violation of 16.2 because we are not discrimination only on the grounds of gender, but we are discriminating on the grounds of gender plus. Now, our court has now increasingly, after Nargesh Mirza of 83, our court has increasingly said that you can't get around that only phrase in Article 16.2 by adopting some other prohibited ground of discrimination and then say that, oh no, I'm not discriminating against you only because you are a woman. I'm discriminating against you because you are a woman and you have got married. That is inconceivable.
Yes.
But here, it's not just a discrimination only on the basis of caste. It's on the basis of a factor which is recognized by the Constitution itself in 16.4. Right? Because 16.4 expressly speaks of underrepresentation. So then it is not discrimination only on the grounds of caste under 16.2.
Gotcha. Lord, then I respectfully submit in the second bullet point, the bar is to be inferred from 341.2 that a route is provided. So all other routes are excluded. As I submitted, my lord.
Right.
And then the bar is that scheduled caste as a
That
whole
point you have
have been
made.
accepted as a class which I
That you have
submitted.
already made.
And then the bar in the last bullet point in 338 that there is a route of the commission, a committee, etc. Now kindly see, my lord, these paragraphs I have mentioned in Devinder.
That's the referring order, right?
Yes, my lord, these 4-5 paragraphs.
We look at them. What are you trying?
Submission is this, my lord. A reading of these paragraphs, my lord, is this. State cannot be denuded of its power. State has to run to the aid and to ameliorate the situation. Lord, these are answers in generality with utmost respect. These are not constitutional answers to upset Chinaya or to meet the reasoning and the findings of Thomas. These are the spate of reasonings running into these 5 paragraphs. That of course the state must have the power to do this. It is not as if there is no ventilation to the grievance. Yes, there is, but there's a route. There's a person identified who will do it as per the constitutional scheme. All these paragraphs run in that tenure. That's the respectful submission.
Thank
Very
you, Mr.
grateful, my lord.
Thank you, Mr. Rup.
And I far exceeded, my lord, your lordship's time.
No, but you are opening.
My apologies for that.
No, you are opening the arguments for your side. So thank you, Mr. Sarup.
May it please, my lord.
Yes.
My lords,
Yes.
much of the ground has been already covered by I won't take much time, which I have already told. I will only submit regard to the, my lord, one thing, the questions framed by that. The first question was whether the provisions of the contained in section 4, subclass 5 of the Punjab Scheduled Act, Backward Classes Act are constitutionally valid, or whether the state has a legislative competence to enact the provisions contained in section 4, subclass 5 of the Act, whether the decision in E.V. Chennaiya versus State of Andhra Pradesh, I reported in 2005, volume 1, SCC 397 required to be revisited. The number 3, my lord, I will address first. Your lordship may see whether yes, sir. My lord, I have already, these submissions have been submitted by my learned friend, Mr. I'll be following that. And that is at volume 2, page 19. And the relevant which would be at page 23. Heading which has been given already there.
You are referring to Mr. Hegde's submissions.
These were submissions, my lord, before the five judges, and I have
Uh,
got the
Mr.
advantage of,
Only 1 second, Mr. Agarwal. Mr. Sarup, which is the, what is the cross reference to your original submissions? Because you gave us 2E, we read that 2-page note. But where are your original submissions, the more comprehensive submissions? You can just give us so that, well, in our notes, we don't miss it. You can, before we rise, you can tell us.
It is on page 76, page PDF, volume 2,
Volume 2,
page 76 PDF.
we got it, Mr. 76 Pinantia. Volume 2.
But I also had the answer to Usha Mehra, if your lordship want at this stage.
Mr. Sagar, you also, you are.
yes, my lords, I was, now your lordship may refer to page 28 of my submissions and the para number 3, in which I have very categorically stated that the appellant sought to contend that the treason in E.V. Chennaiya does not follow the judgment of a larger bench of this honorable court. Indra Sani versus Union of India,
You are referring to
99,
para 3.
para 3, my lords.
Para 3 begins with the Punjab government by a circular.
No.
You are referring to Mr.
Page-
Hegde's submission.
Page 20, internal page, sorry, page 28, internal page 10 of the submissions.
Internal page 10.
28, man. Volume 2,
Volume 2, Mr. Hegde's submissions begin at PDF page 19.
yes, that is, now you're not.
You are referring to your submissions or Mr. Hegde's submissions?
It is Hegde's submissions, my lord, I have said so. It has already been submitted by Mr. Hegde. So I am addressing on
The
those very submissions.
Punjab government by a circular, right?
Yes,
All right, that's PDF page 21 in volume 2.
yes.
Just one second.
Now, my lords, I may have page 28. But in this, may I start? May I? Page 28.
Class 3.
Yes,
The petitioners, appellants have sought to contest.
yes, my lord, this,
Yes,
I'm very sorry for little
No, no.
inconvenience, my lord. Does not follow. This, according to us, is not right. It is absolutely incorrect. And the judgment in Indrasani permitting subclassification was limited, as already stated by my learned friend Sarup, that only other backward classes. I'll be referring, my lord, certain paragraphs. And further, it has in fact been, court has specifically stated that none of these observations will apply to scheduled caste and scheduled tribes. The relevant portions are here, my lord, 781. But I'll first address, my lords, have asked one question there. Your lordship may kindly refer to, your lordship may kindly refer, all right, to these very 81. 781, at the outset, we may state for the purpose of this discussion that we keep aside the scheduled tribes and scheduled caste since they are admittedly included within the backward classes, except to remark that the backward classes contemplated by Article 16.4 do comprise some caste, but it cannot be denied the scheduled caste includes quite a few classes. Then, my lord, 788 is the next para. Further, if we keep in mind the context in which the Article 16 subclass 4 was enacted, it would be clear that the accent upon the social backwardness, it goes without saying that the in the Indian context, the social backwardness leads to educational backwardness, so both of them together lead to poverty, which in turn breeds and perpetuates the social and educational backwardness. They feed upon each other, constituting a vicious circle. It is a well-known fact that till independence of the administrative apparatus was manned almost exclusively by the members of upper caste, the Shudras, scheduled caste, scheduled tribes, and other similar backward class social grouping among the Muslim Christians, practically to entry into the administrative apparatus. It was this imbalance which was sought to be redressed by proving for reservation in favor of the backward classes. In the sense, Dr. Rajiv Dhawan may be right when he says that the object of Article 44 was empowerment of the backward classes. The idea was to enable them to share the state power. we accordingly of the opinion that backwardness contemplated under Article 16.4 is mainly a social backwardness, and it would not be correct to say that the backwardness under 16.4 should be both social and educational. The scheduled tribes and scheduled castes are without doubt a backward for the purposes of class. No one has suggested that they should satisfy the test of social net. While in this regard, then the further, my lord, the two paragraphs are more important. And if I may permit, I'll also state, though these have been many a times stated so, this support my submissions. We may now summarize our discussion under question number 3A. A caste can quite often be a social class in India. If it is a backward socially, it would be backward class for the purposes of 16.4. Among non-Hindus, there are several occupational groups, sects, and the denomination which for historical reasons are backward. They too represent the backward social collectivities for the purpose of Article 16.4. B. Neither the Constitution nor the law prescribes the procedure or the method for identification of backward class, nor it is possible or advisable for the court to lay down any such procedure or method. It must be left to the authority to be appointed to identify. It can adopt a method procedure it thinks convenient, so long as survey covers the entire populace. No objection can be taken to it. Identification of the backward classes can be certainly done with the reference to the caste along with others, groups, classes, sections of people. One can start the process with the caste wherever they are found, apply the criteria evolved determining the backwardness, and find out whether it satisfies the criteria. If does, what emerges is the backward class of citizen within the meaning and for the purposes of Section 4. Similar process can be adopted by the case of other occupational groups, communities, classes, so as to cover the entire populace. The central idea and overall objective should be considered all available groups, sections, classes in society. Since the caste represent an existing identifiable social group class in passing the overwhelming majority of country's population, one can well be begin with it and then go to other groups. Section and classes C, it is not necessary for the class to be designated as backward class. It is situated similarly to the scheduled caste, scheduled tribes. D, creamy layer can be and must be excluded. It is not correct to say the backward class contemplated by the Article 16.4 is limited to the socially and educationally backward classes referred in Article 15.4 and 340. It is much wider. The test or the requirement of social educational backward class cannot be applied to scheduled caste and scheduled tribe who undebatably fall within the expression of backward class citizen. The accent of the section Article 16.4 appears to be a social backwardness. Of course, social backwardness, education, and all are closely intertwined with the Indian concept. The classes contemplated in the article may be wider than those terms. My lord, in this, my respectful submission in this case is that which I'll be also addressing other paragraphs. India's Indira Sahni's case, very sorry, I say. Indira Sahni's case very categorically states and give a finding under what circumstances the concept of creamy layer has to be applied. When the ultimate finding was given that yes, the backward class can be subdivided. There are 7 paragraphs preceding this, my lord, in which the deep concern was shown about the rise of the creamy layer, the rise of those persons in the backward class, may it be any in the backward class, which at the cost of others, they say, they have risen so high. Even Krishna Iyer's in his judgment, Rangachari has also shown this very concern. So it was this concern which actually, I must say, that led to the court to reach on conclusion that it can be subdivided, the backward class can be subdivided. Now, before, my lord, which I'll be addressing post-lunch period, that whether these very circumstances warranted the state to subclass scheduled caste and scheduled tribes? With very utmost respect, whether there was any material to show that the other castes have risen very high, or
Mr. Sagar, that, as we have been repeatedly saying, is a matter
I'm
which will
not,
go back to.
yes, that, but I'm
so
just
that
a
can't
preface.
be
It
decided
is a
here.
preface to that, not I'm going to address on that issue. Only on this, whether in these very circumstances, they might have, it's a possibility that these two castes, Majbi Sikhs and Valmikis, have been suffering, and they are weakest among the weak. On this very issue, I'll be addressing this approach of the court. This very government was erroneous, absolutely, because other classes, if Mr. Sibbal has also, my lord, showed to your lordship 39 classes, in which many other, like for example, cobbler, like for example, snake charmer. And when I verified from that, my lord, these very castes have no houses in the village. They are asked to live in huts outside the village. They are on abject poverty. Some of them indulge in, your lordship may see, theft, etc., which may not be an issue here. The question here is, their non-applicability of mind may be influenced by the political, whatever it is, but their approach was perfectly incorrect, which I would be
We'll break for lunch and come back after.
certainly, I am grateful, my lord.
I know that it is done, what happened to that Justice Ulsa Mehra committee report.
Yes.
Private member we heard which was lapsed, so have that been.
Oh, I see.
I'll report.
So, if you can just formulate your points.
First point, my lord, is this, which I have already stated. That
Yes,
it is
first point was
related
that
to the
judgment in Indira Sahni was limited only to OBCs.
OBCs. And secondly, your lordship may kindly see, the ground which they have taken is that Indira Gandhi says the subdivision, sorry, which I have been using, my lord, my staff is correcting me, but I just forgot out of emotion. I'm very sorry. That's the. So
Elections are around the
Indira-
corner.
Anyway, a great lady is being remembered in this court.
The second is in the context of whether
So
the
there is
creamy
a-
creamy layer can be excluded. Indira Sahni spoke of the subdivision of backward class.
Yes, the basis of them, if it is allowed in subdivision is as per the Indira Sahni's case, so why not we can subdivide it? Our respectful submission in this case is citing these judgments is that it was not that they decided to subdivide, there was a reason,
In the context of creamy layer.
creamy layer.
Point taken.
But
Third
whether
point.
you're not.
Third point now.
Third point.
Don't labor a point which you made. Yes, third
Yes.
point.
Now, I'm very grateful, my lord. Now, the third point which you are making, that, my lord, who we are, I have not stated, I'm very sorry. Out of 39 castes, we are also scheduled caste. We are not backward class or educationally or socially backward. No, that is backward class we are. But actually, we are scheduled caste. Out of 39 castes, 37 are our caste. And the reservation has been given to 2 castes. The difference between these ours and this is almost negligible, except this, that this Valmikis are, as said to be, manually scavenging the dirt also, everything. But at the same time, who we are, I'm just going to, as Mr. Sibal has also shown the list, that kindly see the list who we are. Who are, I already saw snake charmer, a person who is cutting the crops, harvesting the crops, labor, cobblers, barbers. These are the persons which has been, your lordship may kindly refer to, very interesting to see that we are like them. We are not different. We have not risen much in the, out of us.
Sagar, you may have a valid point, but again, there we will have to leave it open to you to set this up as a ground before the High Court. I'll tell you why. There
If
may be,
your lordship is,
I'll tell you there may be some point to be deliberated on this on a more factual basis before the High Court, because they have picked up 2 castes, right? Now, suppose those who are excluded are in a position to show prima facie that, look, though we have been excluded, we rank on the same footing as the others who have been included and who have been given this preferential treatment within the SCs. Then the burden will shift on them
of course,
to demonstrate what was it in regard to these 2 castes which the others do not possess. That is, you have excluded others
that
who
can
are,
be,
according to them, similarly circumstanced. So they must then discharge the burden of showing that those who have been picked up are not similarly circumstanced.
it is just being submitted only for the reason that.
That is the factual justification.
Yes,
for the
that's what I
bifurcation.
was submitting, but I have only submitted that petition, the appellant side referred to this very list. In this was not mentioned at all. Rather, it was said that Mochi and other, etc., they are suffering for ages. I asked myself, Mochis are we, laborers are we. Your lordship, very interesting example, the example I give, my lord, which is, if I don't have the evidence, but it is correct that scavenger, your lordship, is collecting the dirt. It is being loaded to a truck. Truck driver is a backward class. Truck driver is a scheduled, another scheduled caste who is not Valmiki. Invariably, this is happening. Very interesting instances. A person who are in
Maybe
this
from the
class,
advanced class also.
my lord, your lordship may see, they may have the reason to say that they are weakest. Very well, they are weakest.
See, but therefore, what the point I'm trying to tell you is that I'm not saying that you don't have a point on this, but this is a point which has to be argued when
But
the constitutional validity of the act
I'm
is
but
challenged.
just saying for the, giving a preface.
You know, your wider point is that bifurcation is per se impermissible.
Yes.
Now, what you are saying is that, look, in the alternative, I'm putting it in the alternative, even if it is permissible, it can't be justified because those who have been excluded by this act from the preferential allotment are in all other respects similarly circumstanced, or at least some of them. May not be all the 37 are similarly circumstanced, but out of the 37, you can certainly establish before the High Court that we fulfill the same parameters of backwardness in relation to those two who have been included.
That's right, my lord. But I am just.
I'm saying something in your favor.
Yes, it seems, in first perception, it seems. I'm very grateful. But as a matter of fact, your lordship may see, let me also submit, there are other points also, that we have not excluded or included in that. We have given a preference. There is a marked difference between preference and reservation on one side, and preference and certainly an exclusion are also not very, your lordship may having a much difference.
So what is the submission?
One way of saying thing,
What is the submission?
submission is this, that they do not have power, and it relates to exclusion. It literally relates
It's
to
already argued by Mr. Swaroop.
exclusion.
The
Yes.
power for exclusion and inclusion solely rests with the parliament, and the state does not have that power.
That is in my favor. If it doesn't have that
That
power,
is already argued.
that is argued. I'm just supplementing. I will not give any details to that. Now I'm supposed to give because he has very elaborately dealt it. That's, I'm grateful to him.
That is the best
But
point. That is the
it's-
best point that you have.
Yes, that's the
So
supplement.
we'll say that the power for exclusion is not with the states. That is a formulation which
Yes,
Mr. Swaroop has substantially argued that point.
Please, my lord.
What is the next point now?
Yes,
Mr.
next point, my lord, I'll come. Please refer to the written written submissions.
Just formulate.
Yes, it is whether the state has legislative competence to enact the provisions contained in section 4, subclass 5 of the Act.
Legislative competence.
Legislative competence, because we are supported by E.V. Chenaiya's case that no, as a matter of fact,
You know, legislative, actually, Chinaya has talked of legislative competence, but I think it jumbled up the issues. Legislative competence is a term which is applied to the division of powers in, not division of entries, in list 1, list 2, and list
yes,
3.
then Chenaiya has,
Really speaking, the power either exists or it does not exist under Article 16(4).
yes,
So Article 16(4) is not a matter of competence, it's a matter of constitutional authorization.
yes, Chenaiya has it,
So,
your lordship, so
I know that
recollect.
one para, they say that
Yes.
therefore it is not referable to entry 41 of list 2 or entry
Exactly,
25.
the doctrine of pith and substance was applied there in that case also, and inter alia stated that actually that this very act is,
Competence they have. It will be very far-fetched to say that legislative competence is not there.
my lord, may,
Because entry 42 of list 2 says state public services.
yes,
So they can enact any.
41,
the entire 41. The entirety of the gamut of state public services falls within the state legislative domain. Your point, however, is that while enacting a law under entry 41 of list 2, you cannot breach a substantive constitutional restriction.
yes.
Because
I was coming to that, my lord. I was.
all legislation,
It is my, if you'll,
all legislation is subject to part 3 of the constitution.
then my lord.
But a part 3 argument does not go to competence, but to
Then
constitution.
my lords may kindly refer to Chenaiya. There are certain, my lord, let me refer it. It was Chenaiya. That it was used
Leave
by.
it at that. I mean, that's okay. They went, there's a passing remark over there in that paragraph.
Let's, my lord, may examine Chenaiya. Chenaiya is,
All right. Why don't you do this? You formulate the point. Let's have your formulation first.
yes, whether,
Not whether. Whether would be an issue. You are now submitting.
it's all right then, because in the written submission, it is written, I have just copied.
That's the problem. You are borrowed Mr. Hegde's arguments and therefore he is not properly framed it and you have to read it. It's better, he should be arguing from your
So tell us, why don't
briefs
you
rather than.
formulate your submission?
Yes, my lords may see. My now submission is the state lacks, my lords, that legislative competence to enact the provision contained in section 4, subclass 5 of the Act.
1 second.
That is my submission is at page 33.
Your submission or Mr. Hegde's submission?
My lord may take me as a Hagde.
impersonation.
Yes, if Indira Sani can become Indira Gandhi.
Why not Mr. Why not
As
Mr.
it
Sagar
is.
come, Sagar become Mr. Hegde?
What is
Then take it as.
What is
Well,
that?
Then after Mr. Swarup's argument, the matter should have been over.
It should have
They are
been.
so homogeneous.
It should have been.
All right.
Sagar is relying on a deeming provision.
Obviously,
Now,
thank
you are saying that the state lacks legislative competence to enact section 4(5) of the Act.
Please kindly refer
Now,
to page.
tell us which is the entry under which it will fall.
It will fall under, my submission would be, it neither falls under 41, nor falls under nor falls under 25 of the, this schedule 2, second. Concurrent list. If your lordships may kindly refer to page 33.
Why?
Because as per Chennaiya,
No, don't forget Chinnaya, because Chinnaya is what we are reconsidering now,
yes.
right? For us, Chinnaya is not of a higher court, in which case we are bound.
No,
We are now
that is, I'm,
you have to argue it dehors Chinnaya.
no, my lord, with respect, if I am saying Chennaiya is correct, then I have to justify his.
Right, but that,
that
we
Chennaiya
can't shut our minds, right? We are a bench of 7. We have to
Of
now
course,
deal with it.
Of course, my lord.
It's like arguing a first appeal. In a first appeal, before a high court, you never show that this is the judgment, my lords. You start with the plaint, you start with the issues, you start with the written statement, you look at the evidence. First appeal is judgment, the trial court judgment is shown at the end.
Yes.
So it's the
your
same thing in constitutional matters. You have to argue it on first principle before us. Otherwise, we
Yes,
get
your
impatient.
lordship may.
As we are tending to.
My lords may refer it. My lord, my respectful submission, if your lordship may kindly refer to page 33. Section 5 of the Act very clearly say that 50% of the vacancies of the quota reserved for scheduled caste in direct recruitment shall be offered to the Balmikis and must be Sikhs, if available, at first preference among the scheduled caste. The respondent submits that this amount to an
So, Sagar, rather than reading the submissions, why don't you form your
Just explain it to us, because why do you say it doesn't fall under entry 41? We got the point that this is unconstitutional because it breaches Article 16(4). That's a valid point.
I am very grateful, my
Valid
lord.
in the sense
Now I
not-
will explain.
Not
Now I
valid in
will-
approach, not valid in
If,
necessarily
that's why,
conclusion.
if we kindly refer to the Act says, Act has made a subdivision on the basis of the caste. On the basis of the caste, it has been done, not in order to achieve any other objective like, for example, for appointment, furtherance of your lordship may see appointments or a reservation, giving a
Can we
reservation.
suggest one thing? Can we suggest one thing? We've got your point. But it brings us back to your central point that this is a reservation on the basis of caste.
Yes.
Now, assuming you're right, we proceed for a moment to test your argument on that you are entirely right. So then, which is the constitutional violation? The violation is of 16(4), not of legislative competence.
Your lordship.
Unless you say that the field is exclusively reserved for Parliament under entry 97.
No, that
That
would
will not say.
That would be because here your lordship is reconsidering Chennaiya. I am repeatedly, my lords, may saying one thing only, that the finding given in the Chennaiya in this regard is perfect. Your lordship is going to consider whether it is wrong or right, or it is as per law. But
Right, but
that
we are
is why,
trying to understand why, according to you, is it lacking in legislative competence?
that's why it
Just
was,
explain, because, see, legislative competence.
no, my lord, legislative competence otherwise is there. Of course.
That's
Yes,
the point which I'm trying
Otherwise
to
is
tell.
there if I say, but it is absolutely a violation of the constitutional mandate under your lordship may Article 341. That's why on the next
So,
page,
Sagar, that has been amply argued by Mr.
that I
Sarup
understand.
for last
I
few
will
hours.
not be elaborating at all like Mr. Sarup.
Say-
I'll be just
so
giving.
it doesn't mean that if the same thing is said 10 times,
No,
it will have a more value.
all right, then
And
my
Mr.
lord,
Mr.
my lord
Sagar,
may consider
back
this.
to the drawing block. The validity of a constitutional provision can be challenged on 3 counts.
Yes, my lord.
One, that
Legislative
the legislature which enacts the law does not have competence to enact
Yes.
it. 2, it is in violation of Part 3.
Yes,
3, it is in
Or
violation
any
of
other
any other
constitutional provision.
constitutional, substantive constitutional
Provision.
provision. Now, what we are trying to tell you is that you can't mix the first with the second.
that your lordship may, I confine only myself to the, it is the.
That's right.
I'm only
All right,
confining
now what is the
myself,
next
though I
one?
had elaborate submissions, which
right, we'll consider.
my lords have said this has already been dealt by my learned friend. So therefore, my lord,
What is the next point now, Mr. Sagar?
Next point.
Your submissions will read, your submission as well as Mr. Hegde's submission. Both will read. So your submissions are prior to Mr. Hegde's submission.
Now, what is the next point, Mr. Sagar?
Point is the now my lord remains the only one.
Yes.
That is again, I'm saying, then now let me refer to the E.V. Chinnaya's case, then I'll close my submissions.
All right. Can you formulate what part of Chinnaya that you are adopting as your argument?
Yes, I will be, let's.
So instead of reading Chinnaya,
Yes,
what we would suggest is you can certainly say that I'm adopting the reasoning in Chinnaya as my own.
yes.
So just formulate that because that might appeal to us better because
Your Lordship, may see, I very respectfully submit that the finding given by the Chenaya in his judgment regarding this very. Yes, if Your Lordship may see, that the subdivision made by the state is absolutely and the violation of the Article 341 for the simple reason
yeah.
that it cannot be tinkered with at all to the presidential list of the scheduled caste and.
This point you have made. Thank you. Thank you, Mr. Sagar. Yes, Mr. Hegde.
I'm not allowed to read Chennaiya. No, my lord, there is one.
Not after it has been read by 7 or 8
No, my lord, in this case, there is
What
one
happens, Mr.
paragraph.
Sagar, when you drive, if you have driven a long distance, when you drive, there's something called white line fever. You see constantly that white line on the middle of the road. For judges, it's black line fever. You're constantly seeing the printed word. So that's why you want to be.
What your lordship has read it many a times, no doubt about it. But as a matter of fact, if your lordship may see, I may suggest something, it might come. You never know it. Law is always, my lord, have a many ramifications, many branches.
If you formulate
Allow me
even
to-
now, in a minute, if you formulate what in Chinnaya you are trying to emphasize, we'll take it. We have no difficulty.
Yes, I will, with reference to that, I'll refer only 2-3
Mr.
paragraphs.
Sagar, minds are open until the last word in a matter is said. But as the argument progresses, it has to be more and more chiseled and distilled then.
That's all right then.
Thank you. Thank you, Mr. Sagar. Yes. Yeah. Will you formulate your point now?
Yes, sir. My lord, I have 6 submissions, my lord. My lord, with respect, my lord,
Dr. John, can we have a formulation? What is the first point?
first point is, my lord, whether the decision in E.V. Chinnaya is correctly decided or not. My contention is that it is correctly decided, my lord. And to supplement this, my lord, I have supplementary issues, my lord. Whether there could be any political factors in the identification or in the case of provision or not, my lord. To my understanding, my lord, there cannot be any political factor, my lord. And then the third is, my lord, whether the scheduled caste are caste or classes, my lord. So this is well settled, even in Indra Sani, my lord, that scheduled caste are not caste, they are classes, my lord. And the class is always a homogeneous class. You cannot bifurcate it. If you are bifurcating it, then it will be an arbitrary exercise, and it will hit by the provisions of Article 14, my lord.
Just 1 second. And bifurcation will violate Article 14. Yes. Right. Then 3.
Whether the list of scheduled castes prepared by the president in terms of Article 341 of the Constitution of India, could be tinkered by the state by enacting a provision under Article 15 and 16 of the Constitution or not, my lord. That
So
is the,
we will just reframe your proposition that the state cannot tinker
yes, my lord.
with the list of
Because-
scheduled castes
Because once the entry, as Mr. Sarup
notified
has
by
said,
the
my lord,
president, notified by the president.
the caste, once it is added to entry, my lord, the entry is added to the list, my lord.
State cannot.
Thereafter, state, even the center cannot do it,
Absolutely your
only
spot.
parliament can do it, my lord.
You're absolutely correct on
Yes,
that.
ma'am.
Now what's the next point?
Then next point is, my lord, what is the connecting thread of all these castes, my lord? That is very important, my lord. Nobody has answered that. The connecting thread is, my lord, untouchability. For backward classes, the social and backwardness is the only criteria.
1 second,
But-
just 1 second. The connecting thread, we'll say for the notified castes,
Yes, my lord.
is
Is untouchability, my lord. And which is abolished by Article 17, my lord.
say into brackets prohibited by Article 17. Right,
Then my last point is, my lord, that whether the caste-based reservation is permissible.
we'll say caste-based reservation is not permissible.
Yes,
That's
my
it.
lord. So, if yes, whether such action is contrary to state of Madras versus Champakam Durai Rajan, my lord.
Yes.
So, to make good this, my lord, I want to go to the Constituent Assembly debates, my lord, which is in volume 2B and pages 1 to 4.
2B page 1 page.
Page 1 to 4, my lord, and the
All
first
right, just
page,
go to it.
it start, my
Go
lord.
to it right away. Page 2. आगे जाइए थोड़ा सा. ये बघून मुझे एक अच्छा लगता है आगे तो.
Under the Constituent Assembly has debated Article 300A and 300B, my lord, on 17th of September 1949, my lord.
PDF page 4.
Volume
Page 4.
2. Volume 4A, my lord, I'm sorry. I'm sorry, my lord.
Argument is, Mr.
No, no,
Chauhan,
I thought the earlier one, that is my submission, my lord, at 2B is my.
so page 2 contains the Constitutional Assembly of India debates.
It is there in the submission also, my lord.
Yes,
My lord, may come to page 2, my lord.
yes.
The object, after the articles, my lord, the object of these articles, this is Dr. Ambedkar's statement before the Constituent Assembly, my lord. The object of these two articles, as I stated, was to eliminate the necessity of burdening the Constitution with long list of scheduled caste and scheduled tribe. It is now proposed that the President
Actually, see the last sentence, the object, that is the most important part.
Yes,
Very celebrated statement of
Yes,
Dr.
yes,
Ambedkar.
yes, ma'am.
The object is to eliminate any kind of political factors having a play in the matter of the disturbance in the schedule so published by the president. That's why you are saying that you can't tinker. Once
Yes,
it is
ma'am.
notified, Dr. Ambedkar said you can't tinker with
Yes.
it, then it's only the power of parliament.
Yes, ma'am. Once the list is prepared, my lord, and the entry is added to the list, thereafter, whatever treatment is to be given.
Has to be by parliament only.
No, my lord, parliament can do it, that is different thing. But state has to treat every person who is forming part of that list
Similarly.
similarly. If they are treating them differently, that will be unconstitutional, my lord.
Fair enough.
An
Got the
arbitrary exercise, my lord.
Fair enough.
So, my lord, if we see Chinnaya has cited, my lord, this.
Chinnaya cites this speech of Dr. Ambedkar.
Yes, my lord.
That's, we have seen that.
Yes, my lord. And in this Mandal, my lord, the meaning of class and caste was, then I come to the next point, my lord, whether they are class or caste, my lord.
Yes.
So, in para 49, my lord, of Mandal, my lord. This is volume.
Indrasani.
This is volume 5, my lord. And page is, my lord, 190 to 745, my lord. And
Para?
this is at page 350, my lord.
PDF,
Yes, yes, my lord, 350.
para?
This is para 49, my lord. And it is there in submission also, my lord.
No problem. We just look at quickly, we'll look at that.
Meaning of class and caste.
Para?
Right, huh?
Para 49, my lord.
PDF 354.
39 is.
SCC page number is 377, my lord. 350 is the bold page number, my lord. Meaning of class and caste. To identify the diversity of meaning of the word class and caste that constitute their inner complexity, to formulate the question
Go to the
about.
next para. Go to the next para.
Yes, madam.
Then they give the dictionary.
Then these are dictionary
Skip that.
meanings,
Go
madam.
ahead, go ahead.
Corpus juris secundum.
Go further
Black
down.
Law Dictionary. Now come.
Then, my lord, we come to page, this para 63, my lord. That is at page 353, my lord. Article 15, Article 15.4, 16.4, and Article 341 do not speak of caste, but only class. The learned counsel, particularly those appearing for anti-reservationists, have stressed that if the makers of the constitution had really intended to take caste as conveying the meaning of socially and educationally backward class, they would have incorporated the said word as caste or caste, my lord. In Article 15.4 and Article 340, Clause 1, as socially and educationally backward caste or caste, my lord. This was suggested by Justice Pandian, that this should have been the frame of
Para
that
64.
provision, my lord.
Dr. Chauhan, go to para 64.
Yes, my lord. The word caste is not used in the constitution as indicative of any selection of people or community except in relation to scheduled caste, which is defined in Article 366, Clause 24. However, the word caste in Article 15.2, 16.2, and 29.2 does not include scheduled caste, but it refers to a caste within the ordinary meaning of caste, my lord. Then the word scheduled caste came into being only after notification of President under Article 341, as Mr. Swaroop has contended, my lord. It would be appropriate in this connection to recall the observation of Justice Fazal Ali, my lord. These Mr. Swaroop has read, my lord. Then Justice Matthews, I may read para 65, my lord. In his separate judgment in Thomas, expressed that it is by virtue of the notification of the President that scheduled caste came into being. Reference also may be made to the observation of Justice Krishna Iyer in Akhil Bharat Soshit Karmachari Sangh vs. Union of India, where he has said criminological similarities are an illusory guide and we cannot go by verbal verisimilitude. It is very doubtful whether the expression caste will apply to scheduled caste. At any rate, scheduled castes are identified by their tribal denomination. A tribe cannot be equated with a caste. As stated earlier, there are sufficient indication in the constitution to suggest that the scheduled castes are not mere
Dr.
castes.
Chauhan,
Yes,
just read para 82. I think, after citing all the cases, just see how they summarize their discussion. You can actually see para 81 first. Though there is tremendous.
PDF page 361.
So there is a tremendous ambivalence in a host of judgments rendered by this court. Not even a single judgment has held that class has no relevance to caste at all whenever caste system is prevalent, my lord. To this, my lord, my respectful submission is this, my lord. For formulation of that list, you can have a caste, my lord. and the caste is a class for the purpose of entering into that list, my lord. Once that class, that
Actually,
caste.
there is a little bit of a confusion
Yes,
here.
yes, madam.
What they are saying is not that a caste can never be a class.
Yes, ma'am.
What they are saying is, you can't treat a caste as a class unless it satisfies the parameters of social and economic backwardness.
Yes, madam.
In other words, if a caste satisfies the requirement of social and economic backwardness,
Yes, ma'am.
then it becomes a class.
Yes, madam.
Take any forward community.
Yes, madam.
We'll not name the community.
Yes, madam.
That community, can that be a class, a backward class for the purpose of 16.4? No. Why? Because it does not fulfill the parameters of backwardness. So if you see now, just read this a little carefully.
From President.
Para 82.
82.
Yes, ma'am. Collating the aforesaid views.
Nevertheless, it may be stated that caste neither can be the sole criterion, nor can it be equated with class for the purpose of Article 16.4 for ascertaining the social and educational backwardness of any section or group of people, so as to bring them within the wider connotation of backward class. Nevertheless, caste in Hindu society becomes a dominant factor or primary criterion in determining the backwardness of a class of citizens. Unless, now this is very important.
Yes, madam.
Unless caste satisfies the primary test of social backwardness as well as the educational and economic backwardness, which are the established, accepted criteria to identify backward class, a caste per se, without satisfying the agreed formulae generally, cannot fall within the meaning of backward class of citizens under Article 16.4, save in given exceptional circumstances, such as a caste itself being identifiable with the traditional occupation of the lower strata, indicating the social backwardness.
Yes, madam.
Now, if we apply this test
Yes, madam.
to the Balmikis
Yes,
and to the Mazhabi Sikhs,
Yes, madam.
they clearly form a class. Because what our court is trying to say in this para, it's not a general assertion that, look, a caste can never be a class. They say, before you can come to the conclusion that a caste is a class, that caste must satisfy the yardsticks of backwardness, whether it is social, educational, or other types of backwardness.
There is a common.
In this case, it is no one's case that they don't satisfy the indicia of backwardness.
Yes, madam.
In fact, your case is like them, you also satisfy the
Yeah.
indicia.
Yes, madam.
So the fact we are dealing today, everybody who is before us
Yes, madam.
satisfies the requirement, that indicia of backwardness.
Yes, madam.
Because this is a battle between the backward and the backward. It's
Yes.
not a battle between the backward and the
Yes,
forward
yes,
in
yes,
this
madam.
case.
Yes, madam.
So all of you satisfy the requirement. That's why you're all inserted in the presidential list in the
Yes,
first
yes,
place.
madam.
So it's necessary to understand what para 82
Madam,
means.
with
exactly,
respect,
no?
we have to test it from a different angle, madam.
Yes.
Because we have to test it only from the angle of untouchability. Because the caste, suppose 37 castes are there, we are testing on Punjab.
Not
So-
really untouchability alone. It was not that, every one of our scheduled castes suffered from untouchability in its pristine form.
No, no, madam.
There may have been many scheduled castes who did not suffer from the kind of untouchability that we associated with the social spectrum, but they nonetheless suffered discrimination. It may have been a form of untouchability,
My lord,
Social backwardness.
social backwardness, social
that, my
ostracism,
lord, Justice
not
Ramaswamy-
associating with them socially,
No,
being
Justice
confined to very
Ramaswamy has-
menial occupations.
Justice Ramaswamy has written a concurring judgment from state of Karnataka. So we can go to that, my lord. We will find, my lord.
इसमें और कुछ है?
95 देख.
जरा para 95 देख लीजिए जरा.
That's what is followed from my lord, the Chief Justice is said in so many words by Justice Jeevan Reddy.
By Justice
Jeevan
Reddy.
Jeevan Reddy. Can I
So many words. Just take para 782, 784.
Yes.
There's so many words that a caste is a backward class once it satisfies these tests.
correct? Just see, Dr.
I'm-
John, since that has been read, let's clear it, but just, yeah.
782 for a moment, Bharat, just kindly see that.
Okay, okay.
778,
778.
is exactly also on that one, 778.
Bharat, I just read three lines, Bharat. Just come to 7.
Just 1 second, we'll go to it. And page?
Bharat, this is Bharat, in your PDF. And what you will find this, Bharat, at page 693.
My lord, may kindly peruse page 779, my
I
lord.
just read two paragraphs, that's all. Kindly come to Bharat, PDF 693, Placitum F. Placitum F, Bharat. May I place it, please? Class item F, any authority entrusted with the task of identifying backward classes may well start with the castes. It can take caste A, apply the criteria of backwardness evolved by it, so to that caste and determine whether it qualifies as a backward class or not. If it does qualify, what emerges is a backward class for the purpose of 16.4. The concept of caste is not, in this behalf, is not confined to caste among Hindus. It extends so and so, so and so. Now let's come to para 784 on the next page. Again said even more clearly. Kindly come to 784. The next page.
Yes, yes.
The only basis for saying that caste should be excluded from consideration altogether while identifying backward class of citizens for the purpose of 16.4 is clause 2 of 16. This argument, however, overlooks and ignores the true purport of clause 2. It prohibits discrimination on any or all of the grounds mentioned therein. The significance of the word any cannot be minimized. Reservation is not being made under clause 4 in favor of a caste, but a backward class. Now, this is important. Once a caste satisfies the criteria of backwardness, it becomes a backward class for the purpose of 16.4. Even that, this is what is being submitted right now. This answers that. And then the pre-lunch debate, the next line, even that is not enough. It must be further be found that the backward class is not adequately represented in the service of the state. In such a situation, bar of 2 has no application whatsoever. Because not only
Becomes a backward class of which side?
So, Millards, to answer what fell from her ladyship, this is the clear answer. The caste, once it satisfies the requirements, Millards, given here, social educational backwardness is a backward class. That is why any.
It's clear, actually, very clear.
Absolutely clear, Millards. Absolutely clear.
Just one more para Malaj will permit. 778. That
And
also
let's-
puts it very tightly. 778. Indeed, there are very good reasons why the Constitution could not have used the expression caste or caste in Article 16.4 and why the word class was the natural choice in the context. The Constitution was meant for the entire country and for all time to come. Non-Hindu religions like Islam, Christianity, and Sikh did not recognize caste as such, though, as pointed out here and above, caste did exist even among these religions to a varying degree. Further, the Constitution is supposed to be a permanent document expected to last several centuries. It must surely have envisaged that in future many classes may spring up, answering the test of backwardness requiring the protection of Article 16.4. It therefore follows from the use of the word
2 and 784 are.
779 is also important. Madam.
Then one
779.
more thing, very interestingly, I just wanted to show you, I mean, we don't read it right now. You know, in earlier part in the morning session, I gave that example of the aerosters.
That's the
Aerosters, that is footnote 143. At page 690, Air India was Nagesh Milra.
Yes, well, that's right.
What Articles 15.1 and 16.2 prohibit is that discrimination should not be made only and only on the ground of sex.
That's what 784 says, Millards. Here it is not just that, it is also inadequacy of representation. So the only 16.2 argument is specifically rejected on this ground, what fell from your lordship, Millards, in the pre-lunch session. Clearly.
Just note all these para 766. Note that 766, 771, 772 to 778, then 779, and then that's 779, that's it.
And 784.
Yeah, 82, 84, and 96, 97. 796, 97.
Complete
I have it in a note, which I'll upload, which has all the quotations, so that it's easy for your lordship.
Complete answer.
Let's, just one comment. All these passages are only in the context of reservation for OBCs. Now, OBCs had to be justified at that stage. Because Mandal was concerned not with scheduled castes, but with OBCs.
But Mr. Hegde, even within the OBCs, the point is that a single caste can
Yes.
become a class provided. We see your point. You're saying, but no. In the case of SCs, because of Article 341,
Yes,
it's
it's
the
a separate
entirety
thing altogether. I'll put it in.
All right.
I just
We'll
didn't want
hear
the
you.
moment to.
Now we'll wrap up.
Carry on.
We got the point. Let's Dr. Chauhan conclude.
Yes, ma'am. My lord,
Yes, Dr. Chauhan.
The next, my lord, issue is the theory of classification, my lord.
Yes,
How
sir.
you can classify, my lord. What Mandal has said about classification, my lord. Now, every offense, then even in these proceedings.
So what is
it-
the submission, Dr. Chauhan, on
my
classification?
submission is, my lord, they are enabling provision only for the purpose of making classification, but it is not discretionary, because it is not discretionary for the state that they can allow some people the benefit and they can disallow some people that benefit, my lord. If a person is forming part of in a list, my lord, then they cannot discriminate, my lord. And this issue was considered by the 11 judges bench in Madhav Rao Scindia's case, my lord, and even Keswanand Bharti, my lord, 486 para, my lord. The Supreme Court has said that this is a controlled constitution, my lord.
Dr. Chauhan, you've made a point. We are going to put it to the other side. And simply put, your point is this, because this is a very valid point. That suppose the state, now in this case it's two castes. Some state says that, well, out of my 86, I'm identifying only 7.
Yes, my lord.
You leave out others
Yes, my lord.
who are similarly circumstanced. Can the state do that? Can they say that, look, I have, say, 25 castes which fulfill all the parameters of backwardness.
Yes, my lord.
Out of the 25, I'll only take 3.
Yes, my lord.
Normally, conceptually, an under-inclusive classification is a valid classification.
Yes, my lord.
The legislature does not have to deal with everybody to deal with someone. But I'm not sure that can apply over here. Because if there are a range of castes which are equally backward,
Yes, my lord.
can you then say I'll pick out only 2? But that again, that point is perhaps something we should leave when the challenge comes up before the High Court, you see, or before the two-judge bench, whatever we.
With respect, my lord.
I'll give you another example.
Yes.
Suppose in this case, they had picked out only Balmikis
Yes, my lord.
and left out Mazhabi Sikhs.
Yes, my lord.
All right. Could the Mazhabi Sikhs not have argued that we are as backward as the Balmikis? Why have you left us? You are only taking the Balmikis. Or suppose they took up only the Mazhabi Sikhs.
Yes, my lord.
Can the Balmikis not have argued that, look, why are you taking up only the Mazhabi Sikhs? We are similarly situated.
Yes, yes, my lord.
Which means, therefore, that those who are excluded can always challenge that classification under Article 14 on the ground.
Yes, my lord.
That, look, we are equally, and we fulfill all the indicia of backwardness. But the state can also rebut it by saying that we can classify castes by looking at the extent of backwardness.
Yes.
We want to deal, as Brother Gawai said, we want to confer benefits on the most backward.
Yes, my lord.
But while conferring benefits on the most backward, you can't ensure that some who are most backward, are only given while the others are left out. Otherwise, this will become a very dangerous trend in, popular appeasement.
Yes, yes.
Some state governments will pick out, a few castes. Then another state government will pick out another set of castes. The idea is not to allow, popular politics to play out in granting reservations.
That's why Dr. Ambedkar has said that there should be no political
So
factors, my lord.
even if we don't accept your wider submission, there is undoubtedly some substance in what you people are all pointing out to us, and we'll have to tailor it by laying down criteria.
Yes, my lord. But my lord, may kindly peruse Madhav Rao Scindia judgment, my lord. 2 paragraph of that is 11 judges bench, my lord.
We have dealt with it in Article 370 recently. The article that is the privy purses, no?
Yes, 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 my lord. Para 117 and 170, my lord.
What is the point that
My
you
lord,
decide?
they say that this is a power conferred on the president to identify, but suppose the president doesn't identify, then it will be unconstitutional. He cannot do it. He has a power which is vested, which has to be exercised.
Or power to do what?
To do
Power coupled with duty principle, my lord. That,
Madhav
what?
Scindia, yeah.
Mother of Scindia, it concerned with the privy
my
person.
lord, may kindly peruse that.
No, but it dealt with privy purses. It has nothing to do with Article 341.
My lord, that is there. From there, we have taken that paragraph. 117 and 170, my lord. 2 paragraphs are there. One is by Justice Shah and another is by Justice Hegde, my lord.
Volume 5.
My lord, this is volume.
Where is it?
My lord, in the PDF volume.
Scindia doesn't deal with
Like वाला था ना वो, हाँ. Just.
In Madras, India, what happened was
Yes, my lord.
that the rulers were de-recognized
Yes.
by an executive act.
Yes.
Though the constitution specifically recognized their status as rulers.
Yes, my lord.
Therefore, it was struck down on the ground that what the constitution had done by an express recognition, you could not undo by an executive order.
Yes, my lord.
Subsequently, they amended the constitution to abolish privy purses. That's why in the second round, before Justice L.M. Sharma,
Yes, my lord.
the abrogation of privy purses was upheld because it was a constitutional amendment.
But that is only for the purpose of principle, my lord. That is for a different aspect. But the principle which was dealt by this honorable court.
बताइए कौन सा पैरा?
My lord, this is in my sequence of submissions which we have given, my lord. And this is at page 108, my lord. The paragraph, my lord.
Okay. It's not there. Huh? It's on the screen actually. Okay. Sister, it's on the screen, huh? Not on the. So which para?
Para 117, my lord.
All right.
But could I go to page 109 in the top? There is a page 109, my lord.
Yeah, para 117.
117, it start in the earlier page, my lord. There are many analogous provisions in the constitution which confer upon the president a power coupled with duty. We may refer to two such provisions. The president has under Article 341, 342 to specify scheduled caste and scheduled tribe, and he has done so. Specification so made carries for the members of the scheduled caste and scheduled tribe certain special benefits.
Seats in the House
Reservation seat in the House of People and in the State Legislative Assembly by Article 330 and 332 and of the numerous provisions made in Schedule 5 and Schedule 6, it may be noticed that scheduled caste and scheduled tribe are specially defined for the purposes of Article of the Constitution by Article 366 class 24 and 366 class 25.
What they are saying is
Yes, my lord.
that since the power to, once the president makes a notification,
Yes, my lord.
thereafter any deletion has to be by a law made by parliament. The president can't just issue a notification and delete any entry.
Yes.
That's the point.
Well, now, my lord, because the principle which was settled in Indira Sani, my lord, in 9 judges bench, that this is a classification, my lord. Now, in Nagraj, this honorable court has taken a view, this is a enabling provision and a discretionary remedy, which has led to scrapping of reservation in promotion almost all states, my lord. The interpretation should be as per the mandate of the constitution and my lord, whatever my lord have laid down in the larger benches, my lord. But still, that enabling provision and discretionary remedy was a part of Article para 284 by Justice Thoman, my lord. He was a dissenting judge in that. Only he has used that phrase, which was adopted in Nagraj, my lord. And this is a facet of that only, my lord, that we will provide reservation to one caste and we will not provide reservation to the other caste.
All right, we got the point now. What's the next point, Dr. Chauhan?
Or para 788 of Indira Sani, my lord, that is at in volume 4A, at page 693, my lord.
Page?
693. Paragraph 778.
No, my lord, 788, my lord.
788.
My lord, it is at 693 page. Could I read, my lord?
Yes.
Further, if one keeps in mind the context in which Article 16.4 was enacted, it would be clear that that assent was upon social backwardness. It goes without saying that the Indian context, social backwardness leads to educational backwardness, and both of them together leads to poverty, which in turn breeds and perpetuate the social and educational backwardness. They feed upon each other, constituting a vicious circle. It is known, a well-known fact that till independence, the administrative apparatus was manned almost exclusively by members of upper caste. Sudras and scheduled caste and scheduled tribes and others similarly
It was
backward
already
class.
read. This paragraph is already read.
Yes, sir. No, this has not been read.
Yes, yes.
Yes, it has been read.
My lord, last place item H, my lord, we are accordingly of the opinion that the backwardness contemplated by Article 16(4) is mainly social
That has
backwardness.
already been read, Mr. Soder. Mr. Jawan.
What they held was the SCs and STs don't have to satisfy the test of social backwardness
Yes,
because
yes.
they are socially backward. That's
Yes,
what they
yes.
have said here.
Yes, yes, yes. Sir. And the connecting thread is only the untouchability, my lord.
So,
Because
is that all?
caste,
We got the point.
which
We made a
form
note
part
of that.
That group, my lord, in the list, my lord, they are basically, that is the main condition to enter into that caste.
Therefore, you can't bifurcate.
Yes,
these
yes,
people.
ma'am. That's why
Thank you.
you
Thank
cannot
you,
buy.
Dr. On. Anything else now?
Just a minute, ma'am. My lord, in general thing, my lord, para 23, 24, my lord.
What are you relying upon that for?
Regarding that untouchability only, my lord, 2018 10 SCC, 396, my lord.
Volume
And
five.
this is, my lord, volume
PDF
volume 5,
It starts page 908.
Which paragraph you are referring to?
my lord, 23, 24, my lord.
935.
Simple, yeah. Tiger.
Could I read, my lord? This brings us to whether the judgment in Nagaraj needs to be revisited on the other ground that have been argued before us, insofar as the state having to show quantifiable data so far as backwardness of the class is concerned. We are afraid that we must reject Mr. Sri Shanti Bhushan's argument. The reference to class is to scheduled caste and scheduled tribe and their inadequacy of representation in public employment. It is clear, therefore, that Nagaraj has, in unmistakable terms, stated that the state has to collect quantifiable data showing backwardness of the scheduled caste and scheduled tribe. We are afraid that this portion of the judgment is directly contrary to the 9-judge bench in Indra Sani. One, Jeevan Reddy J speaking for himself, then his pair is extracted, my lord. The test of requirement of social and educational backwardness cannot be applied to scheduled caste and scheduled tribe, who indubitably fall within the expression backward class of citizens. Then Justice Thoman, though he was a dissenting judge, my lord, his para is also extracted. The only such class of citizen who are socially and educationally backward classes
Yes.
For the purposes of reservation under Article 15 and Article 16, their backwardness must have.
John, what
Yes.
this paragraph says is that for the SCs and STs,
Yes, my lord.
the state need not collect quantifiable data on backwardness.
Yes, ma'am.
Because SCs and STs, by their very by the very nature, are treated as backward by their inclusion in the
Yes, yes,
presidential
yes,
list under Article 341. So to that extent, Nagaraj was overruled, saying that quantifiable data on backwardness, that principle does not apply to the SCs, STs.
So, in that way, my lord, in scheduled caste, once they form part of that list, my lord, then there cannot be a better scheduled caste or a worse scheduled caste or a
That is the point.
privileged scheduled caste, because
You're right, that is the point all of you are making.
if a caste is attaining some better advantage, then the parliament is free to exclude that caste. Even a part of that caste can be excluded.
That's the point which has been made repeatedly.
Yes, ma'am.
Thank you, Dr. Chauhan. I think we have to
Well,
get along now to Mr. Rao and then Mr. Hegde.
I want to place only one important thing, my lord.
Yes.
There is a research article by Professor Owen M. Fish, my lord, and this para 163 is relevant, my lord. My lord, may kindly read.
Where do we get
only
that
one
article?
paragraph, my
Where
lord.
do we get the article?
This is like in our country, this is PDF page, my lord, 432, my lord, the volume which we have given.
Volume 5.
432.
Volume.
What master is having that one?
Same volume. Volume 5.
No, but yes.
Okay. You can pass it in the evening, no problem.
Yes. Well, like in our country, my lord, in the USA also, my lord, for blacks, my lord, there is a campaign that rich blacks should not form part of that group. And to that he has answered this, my lord. Page 163, my lord. Moreover, second line I am reading, my lord. Moreover, wholly apart from consideration of administrative convenience, the decision not to exclude the rich black, even one identified.
It does not cite the US. You know the latest judgment of the US. They have said you cannot use race even as a factor in admissions. They have now gone the other way. So Justice Roberts
Yes.
has said that you cannot use race even as a factor in admissions. They never had quotas.
Yes, my lord.
But they
Their
just
quota
had-
has come after our constitution.
No, they don't have quotas. But now even that has been outlawed by the US Supreme Court. So they are world light years away from the position that we have evolved in our constitution.
No, but in their constitution there is no provision like our reservations, my lord.
As Mr. Hegde says that there's been a regression in that sense from our position in that sense in the US.
No, but they, in their jurisdiction or their jurisprudence, this reservation or relating provisions or relating principle was evolved because of Dr. Ambedkar, my lord. And since in our constitution this principle was adopted, that's why in 58 they have started adopting that. Our constitution came in 50, my lord. So much later they have adopted that principle, my lord.
They have never adopted quotas, and even now, race as a factor has been rejected in the US.
No, because they do not have provision in their constitution, my lord. In our constitution, we have only.
Yes, Mr. Hegde, who wants to argue now? Thank you, Dr. Chauhan. Mr. Rao, yes. Thank you, Dr. Chauhan.
I'm obliged, my lord.
Thank you, Mr. Chauhan.
My lord, while deciding Chinnaya, my lord, there were 4 appeals, my lord, before the lordships, my lord. Lord, one was, my lord, appeal number 6759 of E.V. Chinnaya, my lord. In that, my lord, Mr. Chinnaya represented an organization. He is no more, my lord. But one of the members have there, my lord. Therefore, I am there also, but I must tell you, lordship, one thing. Yesterday, somebody mentioned, my lord, they are representing Chinnaya. Be whoever is representing, my lord, I don't mind.
Mr.
The
Mishra,
point, it is the point which has to be canvassed, my lord.
Mr. Mishra said.
Then secondly, my lord, I appear, my lord, for.
You said that you are representing Chennai.
But Mr. Rao says Chinnaya has no more. Anyway, it doesn't matter.
No,
There, of
I'll
course,
tell you,
it's a
lordship.
constitutional point, no difference.
But be that as it may, my lord, whoever does it, it hardly matters, my
You've
lord.
heard intervener.
The second party whom I am representing is, my lord, civil appeal number 6934.
Give that later. Tell us the point.
Yeah, the point, my lord, is this, my lord. While the legislature, while enacting laws, empowering the backward people, my lord, cannot tinker with the list, presidential list under Article 341, my lord.
That is a point which has already been made. What
That's,
is that?
therefore, I'm not reporting that. Second thing, my lord, which I wanted to point out, my lord, one of the major questions before your lordship is whether Chinnaya requires reconsideration and whether the Chinnaya was wrong, my lord.
Right.
My lord, we have to look at from the judgment of Justice Chinnaya, my lord, from the point of view of what it was deciding, my lord.
Right.
The facts are very necessary. For that, my lord, kindly take the judgment, my lord. Chinnaya judgment, my lord.
Actually,
I will not.
The facts were read out to us.
The facts will not be narrated, but how the court has dealt with it.
Raju
What
report
were
and everything
no,
is read out.
Since that's the major this thing, my lord, I would like, I will beseech your lordship, my lord. I will not read the entire judgment. There are 4 or 5 paragraphs, my lord, which I want to show.
All right.
What were the questions before the court, my lord? Your lordship may kindly come to my lord. What were the questions? Page 800, my lord.
Of volume 5?
I'll give the equal, yes, my lord, of volume 5, my lord.
Which para do you want us to read?
Para 55, my lord. Lord, this is Justice Sinha, my lord. He dealt with the questions. What were the questions before the High Court, my lord? The questions before the High Court were whether the state's legislative power is curtailed or eclipsed by any provisions of the Constitution, whether the impugned act is beyond the legislative competence of the state and is violative of Article 341(2), whether the impugned act violates Article 14, 15, and 16, whether the impugned legislation is a colorable piece of legislation. Now, my lord, your lordship may kindly go back, my lord, to page 409, my lord, which is equivalent to, my lord, 789. Para 12, my lord. What was before this court, my lord?
Violative of, yes.
From the pleadings on record and arguments addressed, this is Justice Santosh Hegde, my lord. Whether the impugned act is violative of Article 341(2) of the Constitution.
See item 3, question 3.
Now, my lord, this is answered in para 26, my lord, after discussion everything. Then, my lord, whether the impugned enactment is constitutionally invalid for lack of legislative competence, para 31. Whether the impugned enactment creates subclassification or microclassification of scheduled castes so as to violate Article 14 of the Constitution, which is answered in para 37, my lord. My lord, I am not reading the reasoning, my lord, because it has been done and because my first proposition considers all that has been argued, my lord. But there is one thing which I want to point out, my lord. As the questions arose, my lord, what happens to the backwards who are below, who are not dealt with? My lord? For instance, my lord, in the state of Andhra Pradesh, what had happened, my lord? There were 59 castes, my lord. 59, 60, my lord, be that as it may. They were divided into 4, my lord, A, B, C. And class A, my lord, was given, my lord, comprising of 12 classes. Category A, comprising of 12 classes, were given 1%, my lord.
12 castes or classes?
12 classes, my lord. 12 castes, my lord.
Yes.
Then part B, my lord, category B, comprising of 18 castes, my lord, were given 7%, my lord. Then category C, containing 24 castes, my lord, were given 6%. Then category D.
24 castes.
Yes, 24, my lord.
6%.
Fourth is, my lord, 4 castes given 1%, my lord.
4 castes.
Yes, my lord. Now, my lord, what happens is, my lord, earlier, who were getting in the entirety in the 15, my lord, whether they could compete with it, did not do it, we are not concerned, my lord. But 15, I suppose I was eligible for the 15%, my lord. Today, by virtue of being classified into class D, I get only 1%, my lord. That is 24 castes will get 1%, my lord.
So 24 castes, you said 6%.
6%, my lord. But 50 from 24, my lord, 4 castes, 1%, my lord. 12 castes, 1%.
So earlier everybody was competing for the entirety of the 15%.
Entirely. Earlier I could compete for the entire 15%, my lord. So therefore, my lord, in the light of that, this judgment was delivered. That's why I read the questions, my lord. But what were the questions before this honorable court? Now, my lord, what is actually happening is they have tinkered with 341, my lord, second portion. You have varied the list.
You have neither included nor excluded.
No, to say, my lord, that we are still there. No, but you have varied the list, my lord.
Still the same, they are all being given maybe different percentage of.
No, my lord, but today, my lord, what happens is, that's why I said, my lord, 12 people, 12 castes or 4 castes.
There could be other reasons also. What is their population? What is their population ratio? What is their representation in the services?
Well,
That is an exercise to be undertaken by the government.
My lord, that the earlier advocates have shown, my lord, that there is a route to it. If you find somebody has gone above the threshold, my lord, delete them. If you want to bring in new people,
Petition and
do it.
they can't do. That is
but
done by
you
the
are
central
weighing
government.
the list, my lord.
But they are trying to maintain a balance between all the castes.
It's a different matter that for arriving at such a finding, there was no empirical data.
There was nothing.
So that will be going to the merits of the matter.
So therefore,
Whether it is
huh,
permissible or not, that's a question.
That's a
that we are
different
deciding.
question.
whether as a matter of principle, Chinnaiya is right or wrong, we are deciding. But the act may still not pass muster in the absence of verifiable data in regard to underrepresentation, etc.
You know, this is 2005. Then 7, my lord. Initially, my lord, the ordinance was challenged, which was upheld, which was struck down. Then the state came here. Then the legislation came.
To ask us the other side, anybody dealing with Andhra Pradesh on this side or?
No, nobody. Mr. Luthra made a statement that we will abide by the judgment, my lord, as if they have a choice.
Not Luthra.
Dr. Muralidhar appeared for Andhra Pradesh and they said
They said they will abide by it, my lord.
And
as
Mr.
if they
Luthra
have a
appeared for
choice.
Telangana.
Whatever your lordship say will be.
Chinnaiya set aside the act. All right, so Chinnaiya held the act to be unconstitutional.
Right, my lord.
Now, if we in a separate proceeding, if we come to the conclusion that the judgment in Chinnaiya does not lay down the correct principle, that will not per se result in the validation of the act. Because we
Your
do
lordship
not
may
have-
clarify that, my lord.
Because, one second, we do not have any appeal pertaining to Andhra Pradesh before us, right?
There is a
That's
writ
correct,
now, my
ma'am.
lord, filed by some of the people who get benefit by this, my lord. For I think Mr. Venugopal argued.
My lord, I appear for the state of Andhra Pradesh. My lord, the Chief Justice has rightly observed there is nothing by way of an Andhra Pradesh review pending as far as this reference is concerned. So
How is Andhra Pradesh before us? How are the people from Andhra Pradesh? They are interveners or what is
yes,
happening?
no, my lord.
This
Actually,
was
by
part
way of a
that when it was
PIL,
combined
that
state,
is
my
in
lord.
item
One second.
701.22.
Yes, Mr. Krishnan?
My lord, in item 701.22, a writ petition has been filed arraying all the states of the country asking for overruling of Chinnaiya. That is the only incidental basis on which Andhra Pradesh is technically before my lords.
Speaking, in a
We-
collateral proceeding, even if we overrule Chinnaiya,
That's right.
that will have no impact on the act which has been.
Yes,
held
that
to
act has been struck down, my lord, and since the act has been struck down in our own case, we have not reenacted anything in defiance of this honorable court's
It will be
judgment.
open for the state if they want to come with a fresh enactment or not.
Yes.
And only after a fresh enactment comes in the eventuality.
And that will
then
be
we have some claim.
and that will be subject to a challenge.
Why I am not going that far is, my lord, I don't want to come back again saying, my lord, that in view of your lordship, they have reenacted, my lord. Today, my lord, this was actually a political move, my lord.
But Mr. Rao, we will not comment on the facts of the Andhra Pradesh Act in this proceeding, for the reason that whatever we do is not going to affect the mandamus or the certiorari which was issued by this court or the declaration which was issued by this court in Chinnaiya, which was there inter partes. What we will decide here, the only live case which is before us is the Punjab case.
But
Furthermore,
what happens
if
is,
I may
what
just
happens,
say this,
Lord,
my
the
lord.
apprehension is, my lord, a series of litigations would start, my lord. The enactments would come, my lord, because this move in the state was only for a political purpose.
This वो एक मिनट बंद कर दो.
Yes, yes, sir, it's not only money, it's not only lawyers' money.
Petitioner, who is the lead petition, was the lead petitioner and petitioner. And then matter traveled here, it was registered on the name of PC Chinmaya. I was the second or third petitioner there, separate petition that my name is there. I am there, Milad, from the Andhra Pradesh side to represent the scheduled caste. And Milad, here I will just deliver upon whether the backward classes that and the 16th class 4 includes scheduled caste or not. That is the only preview of my argument.
So, Mr. Rao, what else now?
The problems which were raised by the court, my lord, as to what happens within the group who are not then. Lord Justice Sinha has given certain remedies, my lord, which are at page, my lord, for 815, my lord. Apart from that, my lord, a solution can be found out as to how, my lord, these things, reservations have to be worked out, my lord. Yes, my lord, we are seeing, my lord, because of the ground situation, that some people are garnering, my lord, some people are not getting it. They are not getting it because of the socio-political situation that they are not allowed in the village, and the census is taken only in the village, my lord. This has to be restricted, my lord. Maybe one suggestion is, my lord. Suggestion I'm giving as an officer of the court, my lord, not this thing. Well, suppose, my lord, what happens today is, my lord, a person is getting a reservation. Suppose a person is getting reservation, my lord. He gets reservation at all stages, my lord. For instance, at the admission, at the time of school, at the time of college. For instance, he goes into a medical this thing, my lord, he gets the reservation. Then in the job, he gets the reservation. This has to be looked into by the government, my lord, how it has to see, my lord, that how it reaches to the bottom. But it can't be, my lord, that they will tinker with the list, my lord.
That
They are not tinkering with the list.
No tinkering with the list
No,
as such.
they have varied the list, my lord.
No, no.
From 15, I have got one, my lord.
It's not a varying the list, where is it provided in the list?
The list never gives you
The
15%.
list never gives you a percentage that you will be
List
getting
never gave,
10% or somebody is
But
getting.
today,
It has been
but
about
today,
by Mr.
today, my lord, the constitution, in the constitution it is provided that SC/ST would get the, how much they will get, my lord. That has been varied, my lord.
No, it is nowhere it is provided in the constitution.
Where does the constitution say that you'll get 15.5% reservation? Show us the provision.
Adequate representation.
Huh?
Adequate representation.
Adequate representation.
But I am, today, my lord, I have been deprived of it.
But therefore,
My percentage has gone down, my lord.
but therefore, your argument is on the challenge to the act per se, not on that doesn't turn on Chinaya.
Act per se, my lord.
That act is no more in existence now. So
Act is
you
not,
have given
but
some new act.
since we were parties in the original, my lord, and that judgment is under reconsideration.
Whatever happens to the judgment, that can't result in a revival of the act.
That's it, my lord.
You are answering.
All right, thank you, Mr. Rao.
Can I give a small written submission, my lord?
Yes,
Lord,
yes,
I
sir.
also appear in one of the IAs, my lord, filed by a police officer. That IA number is, my lord, 120962 of 2020. I'll give it to the court master, my lord,
Okay.
the matters in which I am appearing.
Yes, Mr. Hegde.
Not the others, I am not repeating, my lord, I wanted to.
They have nothing to argue.
What is the point that you want to make?
Just a bit. I do realize that we are at the end of a long and weary hearing. So therefore, I will not bore your lordships. I'll go on the sound principle that if you don't make a point, you stop boring. Now here, my lords, it's like this. The point that Dr. Chauhan finally came to was what is the distinction that marks a scheduled caste? And the answer given was untouchability. I want to bring to your lordship's notice a judgment in suicide, which sets it out succinctly and our constitutional history. It is 1985 Supplement SCC, page 590, my lords, paragraph 7 thereof. It has been uploaded. Please, my lord. Para 7. Now, it cannot be disputed that this caste system is a feature of the Hindu social structure. It's a social phenomenon peculiar to Hindu society. The division of the Hindu social order by reference at one time to professional or vocational occupation was molded into a structural hierarchy which over centuries crystallized into a stratification where the place of the individual was determined by birth. My lords, after all that preliminary thing, my lords, let me just come to the second part of J.H. Hutton, the last line of 594. J.H. Hutton, a census commissioner, framed a list of the depressed classes systematically, and that list was made the basis of an order promulgated by the British government of India, called the Government Scheduled Castes Order. The Constitution Scheduled Castes Order is substantial.
That we saw yesterday, actually.
Please, my lords. Now, during the framing of the Constitution, the Constituent Assembly recognized that scheduled castes were a backward section of the Hindu community who were handicapped by the practice of untouchability. And this evil practice of untouchability was not recognized by any other religion. And the question of any scheduled caste belonging to a religion other than Hinduism therefore did not arise. The Sikhs, however, demanded that some of their backward sections, the Mazhabis, the Ramdasias, the Kabirpanthis, and the Sikligars should be included in the list of scheduled castes. This demand was accepted on the fact that these sects were originally scheduled caste Hindus who had only recently converted to the Sikh faith and had the same disabilities as the Hindu scheduled castes. The depressed classes within the fold of Hindu society were therefore made the subject of the original Constitution Scheduled Castes Order, subsequently was also amended. Now, my lords, the point is this. The difference between the three categories. Scheduled castes necessarily means that everybody has suffered the taint of untouchability. How untouchable? That's a different thing. There were some people who were merely not seeable. There were some people who were touchable. There were some people whose money could be touched. Now, all of those were put into one class by the Constitution of India in the constitutional order, in the presidential order. And that is why they were called scheduled castes. Now, the castes may be individual.
From where do you find this?
Malady, I just read this. I read this passage.
That is in the judgment.
In the judgment. And my lords, there is supporting material also that can be placed. But, there are several judgments of this court which go on the footing that what distinguishes the scheduled castes from the other backward castes is the taint of untouchability. Once there is the taint of untouchability, how untouchable were you? The Constitution and the Constitution makers at that point of time decided not to go into that question. They formed one homogeneous class. And that homogeneous class they said that you could possibly include or exclude through parliamentary enactment, but in no other manner. So therefore, a court could not add or subtract from it. The executive could not add or subtract, nor can the state legislature tinker with it in any manner whatsoever. That, my lords, is the basis of Chinnaya. And the passages at paragraph 26
That we have seen.
onwards, that was the basis. Now the basis that 341 2 stood as a barrier to anybody else tinkering is supported not only by the speech of Dr. Ambedkar, but it is also supported by another constitution bench, which is a 5-judge bench, which is Bir Singh. Devinder Pal refers to Bir Singh but does not appreciate Bir Singh, my lords. Bir Singh, just get it on the board, 2018 10 SCC. 8. Please, my lords. Yes. If your lordship first sees the question which was posed, the question in Bir Singh.
8 page,
Yes. I'm sorry.
citation page, 312.
312, but my lords, to cut short time, the question in Bir Singh was basically whether if somebody was a scheduled caste in one state, but then migrated to a union territory, would he have the scheduled caste status? And in that context, my lords, if I can place paragraph 36 onwards, where after noticing these various questions, please, my lords.
I think Justice Bhanumati dissented, right, there?
No, there's a slight dissent, but not on in this. Please.
Para 36.
Para 36. The upshot of the aforesaid discussion would lead us to the conclusion that the presidential orders issued under Article 341 in regard to scheduled castes and under Article 342 in regard to scheduled tribes cannot be varied or altered by any authority, including the court. It is Parliament alone which has.
More than settled.
Yes.
Not tinkering is more than settled, right from action committee.
Please, my lords. Now, if
Where is the,
please,
is the state tinkering with the list? Are they
yes, now,
reviewing any,
please,
any
my lord.
entry or adding any
Please,
entry?
my lords, if I'm sorry, my lords.
It is not under our control. It is somebody else is managing there. You are trying to go scroll down and scroll up.
Yes, my lords. So 36 to 30.
You are under our control, no problem.
It goes on the same footing. Now the
quarrel on that proposition that no tinkering is permissible by any authority in the court.
Now let's take this further. If I continue to be a scheduled caste in the list in name only, but no benefits are conferred on me, while benefits are conferred on another scheduled caste in that same list, I am effectively rendered with the stigma of a scheduled caste, but no consequent benefits. That can also happen. In a sense, it's a reverse pran pratishtha. That my caste remains on the list. And yes, you are a Jatav or but for this year, we are taking only Valmikis. Or to use the Maharashtra example, if we say that no Mahars will be taken.
Right, but therefore, this is a challenge not to subgrouping in principle, but the manner in which the subgrouping has been carried out.
It's also,
for instance, that's why I give them the example. Suppose Punjab had said we are taking only the Balmikis and not the Mazhabis, or only the Mazhabis and not the Balmikis. Would that not be amenable to challenge? Possibly, yes.
That would be tinkering, my lords, in my respectful
Right,
submission.
consider that.
In my respectful
Now,
submission.
Mr. We've heard that
No,
for the.
just 1 minute. Just
There's
1
nothing
minute.
new now.
Let me give your lordships an example.
Same is a common refrain now.
Let me just.
We were keen to now put some points.
Yes, I know that. So
you had assured us that you will not repeat anything, but you are repeating the same thing, right? From Mr. Sarup and everybody else.
Please, my lords, one last.
Yes, tell us.
One last reason why your lordships should not leave it to the states. Your lordships noticed Dr. Ambedkar's thing that political ones.
Political.
Now, my lords, India is not comprised only of big states like Punjab, Andhra Pradesh, or anything. There are a lot of small states. And a political decision there. For instance, your lordships have seen the recent violence in Manipur. Now, if only one particular community is knocked out, if you leave the power to the hands of individual states without any reference back to the center, my lords, then what we are asking for is effectively a balkanization of this list. You would be setting up one, as you're to borrow the Chief Justice's language, backward against backward.
All right, thank you. You got that. Thank you, Mr. Now, who's going to, yes, Mr. Meshram, we'll give you 2 minutes, please. Yes, what is the point just formulated, Mr. Meshram?
That 16 class 4, which talks about backward class of citizens, Milord, that does not include scheduled caste, Milord. I am aware about the Indra Sawani judgment.
What is your submission?
Yes, Milord. When the backward classes was included, backward word was included in Article 16. Milord. Before that, the scheduled caste reservation was already settled in the Constituent Assembly. And therefore, the reservation.
That backward classes doesn't include scheduled caste?
No, sir. No, Milord. Therefore, I will take, my lords, to the Constituent Assembly debates, Milord, and the PCUR's documents, Milord. And this argument has never been taken.
But that is being dealt with in
Yes,
yes,
yes.
the larger benches.
No, Milord, this is how nobody nowhere in the history of the Supreme Court, Milord, that argument was built upon by this court, Milord. And therefore, Milord, straight away I'll take to this court on the minority subcommittee's report, Milord, of 1947, my volume 4D, Milord, compilation, filed volume 4D, Milord.
We don't have.
For ABC, B.
4D for Delhi, Milord.
We don't have.
3 to hai nahi, there is no D.
Let me put it in.
4B you said, no?
We have sent the email. Yesterday we have sent the email.
A, B, C, D.
You have to send the email to the nodal council because then only nodal council are authorized to add to our
The
report.
nodal councils, Milord. But I'll just read it out to Milord for that purpose. I'll read it out to the Milord. That the subcommittee then, this is from the B. Shiva Rao, Milord. This is the minority subcommittee report. The subcommittee then examined the demand put forward by representatives of Anglo-Indian community, but thought it advisable that we question of both minorities yes, Milord. Reservation in services. The subcommittee voted on the general proposition that there shall be reservation in the public services for the different communities mentioned in group A, B, and C of paragraph 3, clause 3, Milord. Milord, paragraph 3, clause 3 pertains to Anglo-Indians, that is group A. Group A, Anglo-Indian Parsis, Plains tribesmen in Assam, Milord. Group B pertains to Indian Christians and Sikhs. And population and group C, Milord, for the Muslims and scheduled caste. So now, Milord, they were considering the reservation for these 3 groups, Milord, and they have held, it was agreed that the provisions, if any, regarding reservation, word is most important, Milord, regarding reservation should appear in a schedule up to the Commission Act, Constitution Act, and should have the force of directive of government policy. The decisions were as follows. 1. Agreed by a majority of votes 16 to 1 that there shall be reservation in the services for the scheduled caste. This is Article 296, Milord, corresponding to Article 335 of the Constitution presented, Milord. Then agreed by a majority of votes 9 to 7 that there shall be reservation in the services for Muslims, and so on and so forth, Milord. And then they have specifically considered one more aspect, Milord. that the subcommittee then considered the question as to whether seats should be reserved even for posts for which computation examinations are held. The decisions were as follows. A, agreed by a majority of votes 11-6 that there shall be reservation for scheduled castes in services to which recruitment was made by competitive examination. This is Article 296, corresponding to 335. Now, that 296 was differently worded during that time because the reservation was granted based upon the minorities, and that article, was worded as.
So what is the submission that you are making?
Submission is that the 16 class 4 does not apply to the scheduled caste and their reservation comes from 335. Because altogether this aspect was never
335.
335.
335 doesn't speak about reservation. It only says that
Yes, Miller.
claims of the scheduled caste will be taken.
Into the efficiency of administration. And the danger of making that argument would be that it cease to be a part of the chapter on fundamental rights.
Yes, Miller. That's what we are just explaining, Miller, that what transpired in the Constituent Assembly. This is what I'm exactly proposing.
Mr. Meshram, you are appearing for which matter?
Miller, this is the implement application I have filed
the
for the
Punjab
state
matter.
of Andhra Pradesh.
State of Andhra Pradesh.
No, Miller, not for the state of Andhra Pradesh. The one person who was the petitioner in Andhra Pradesh matter in 2019.
You are one of the petitioners.
And in the Supreme Court also, I was a petitioner in Chinnaya, Miller.
All right.
And therefore, Miller, we have won that case in Chinnaya, Miller. So therefore,
You are saying reservation for the SCs doesn't come under 16.4 at all.
that is historical truth, Miller. That is a historical truth, Miller. And therefore, 296 was worded, Miller.
But then why did the Constitution, what was the Constitution amended to include clause 4A?
That was because,
4B.
And then why was the Constitution amended for the first time in 1951 to bring sub-article 4 in Article 15?
Miller, 16 class 4 is the original article.
No, 16.4.
Yes.
Then if your argument is to be accepted,
yes,
then the reservation in educational institutions would also go away.
Miller, that was Article 15 class violation or class 1 of 15 class violation, Miller. And that was for the backward classes, Miller, not for the scheduled caste, Miller.
No. The GO of Madras government was specifically for scheduled caste, which provided 10% reservation in medical seats.
Communal reservation.
Communal reservation.
Communal, and they said, Miller, in Champakam, that is hit by the discrimination based upon caste, Miller. So therefore, that has come, Miller. But let us appreciate the fact, Miller. This is historical.
No, but then what happens to the entire law which has come from N.M. Thomas onwards, that
Yes, but those judgments
reservations in favor of scheduled caste, scheduled tribe are traceable to 64.
I thought these are all flag bearers of the movement for the justice to the scheduled caste. If we have to today say that N.M. Thomas and Akhil Bharat Ke Shoshit Sangh, they all will be overruled.
Miller, due respect, with
We'll
due respect.
be going
Miller,
back to we'll be going back to the Devdas and the Devdas days.
Miller, neither Indra Sahani, Miller, or the judgments which were rendered before that, Miller, they have dealt with this. Even Miller, the Champakam did not deal with this, Miller. And therefore, Miller, 296 was worded, Miller, that very peculiar.
I'll let you consider it. You have filed your written submissions, right?
No, Miller.
Then give us a
Miller,
short note.
let us see the article 16 class 3, Miller. That 16 class means 10 class 3, Miller, present day 16 class 4, Miller. There is a debate on this, Miller, in the Constituent Assembly, and whether the backward classes
It can't be confined only to a Constituent Assembly debate. Now
Yes.
we have a rich body of jurisprudence on 16.4.
Miller,
We can't say that the
Miller,
scheduled
we-
castes are not within 16.4. This will be extremely deleterious
we
to the
can-
movement for justice to the scheduled castes if we even accept this argument.
Miller,
How
if
can we even
Miller, we cannot reverse the truth in this court.
very
We cannot
very-
reverse the truth, Miller.
very
We cannot
erudite
reverse
judges
the
before us
Constituent
have
Assembly.
gone and decided this whole body of law. We are really just pushing the baton, that's all. We don't want to reconsider this law which has been laid down with such great vision
Absolutely,
and
Miller, but we cannot reverse the truth
passion
while
for
speaking
social
in this
justice.
court, Miller. This is the truth that Article 335 was inserted in the Constitution, means that the discussion took place much before. Milad, much before Article 16 Class 4 came into effect, Milad. Even Milad, the first constitution that is settled by the advisors of the Constituent Assembly, Milad, that includes Article 335, Milad, but that did not include Article 16 Class 4, Milad, in the present form. Milad, first, second.
All right, thank you. We'll give a little time to them now for the rejoinder. Yes, Mr.
Milad.
One second. Now all things good have to come to an end. Anybody wants to make 1 second? Anybody wants to make any submission? Please put it down in one page on a piece of paper. We'll consider it.
Milad,
We have to now.
I will circulate the submission, Milad.
Sure, 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 yes.
I believe your lordship had called for the council for Telangana or Andhra Pradesh.
No.
My lords, may I?
We just were on this.
Mr. Rao, consider you to be Dr. Muralidharan.
Actually, the state of Tamil Nadu case is slightly different.
Either that, someone laughed at this.
Mr. Champaglaji, you're going to be very heavy a submission for us. We will give you a minute or so at the end of it after we hear.
No, he doesn't want to argue. He wants
You want to hand over something. You don't want to argue.
Yes.
Want to
Hand over
something.
My ID is on board.
Yes,
My address is on board.
it's already on board.
It says 9354920.
All right.
May I make a request?
No, now,
With
sorry,
regard to Tamil Nadu.
yeah.
With regard to Tamil Nadu. Tamil Nadu has never been touched upon by anybody.
Who are you appearing for?
I am appearing for 17.3 for a private party who has challenged the act also for an impleading petitioner in 17.1.
Right, but therefore, we are not going to deal with the validity of the act here.
I'm not.
We will be restoring. Yours is a transferred petition, right? Transferred writ petition.
No. This is a writ petition.
Who has filed a writ petition? Oh, I see.
They have filed a substantive petition.
Petition here.
Substantive petition we have filed.
Who is the petitioner counsel in that case?
I am the petitioner counsel, not the local counsel could not be here. I will just take your lordship.
What is your contention?
Two aspects, Lord. With regard to E.V. Chinnaya's case, para 85, I will just take your lordship to
just formulate it.
Lord, there cannot be a class. Lordship was consistently saying that there can be a class. Lord, there cannot be a class within a class. Lord, actually they themselves a class. And what happens
there cannot be a class within a class.
There cannot be a class within a class because the entire people is themselves a class. The lordship will see how.
That's what Lokinath Sota said, and which Chinnaya relies upon. There can't be a micro classification.
Lord, that is what I'm just trying to say in a different format. Because what happens here in Tamil Nadu is, Lord, your lordship will see there are 7 castes out of 76, Lord. 7 castes out of 76, Lord. Namely, Arundhatiya, Chakliya, Madari, Madiga, Padagai.
Right, we've seen the name.
Lord, this 7 class. This 7 class has been classified as Arundhatiya and have been given already for the past 15 years. They are being given 3% in priority. They will be the first person to be considered in the SC list. As my learned senior told, there will not be any chance.
3% out of how many?
Out of 18, if there is only 1% in a post, assuming for a minute, if there is only 1 post for a minute in a
for a solitary post, there
is no reservation.
No. If there is 1 post for SC, if there is 1 post for SC, I'm just trying to say, if there is 1 post for SC, that will be given only for SCA. That is SC Arundhatiya. And they will not be, it will be carried for next 2-3 years. Even assuming if that is not.
You're not considering the validity of the act at all here.
That's why I just wanted to read.
We may not address that matter at all on merit.
I just wanted to read this.
Liberty to file a petition before the High Court under 226.
If your lordship permit me to read 85 for a minute, Lord. As the constitution itself treats the member of the scheduled caste as a single integrated class of the most backward citizens.
85.
It is not competent for the legislation of a state to subdivide them into a separate compartment with a separate percentage of.
That has already been read to us so many
So
times.
many
Lord,
times now.
that is what, my lord, actually, I'm just trying to bring before your lordship is out of
You have
76.
to, we don't mind listening to you, provided you make a good point.
My lord, that's what, my lord.
Today is now we are 15 minutes short of concluding the hearings. Tomorrow is miscellaneous.
I bow down, my lord. That is what I'm just trying to say. Out of 76, they have formulated a 7 as a subclass.
But that's what we told you. We are not going into the validity of the act here. We can't go into the validity of the act absent a proper contest. We'll
I am appearing for 701.
ये पण आला था.
Petition raised against the Union of India. In that case, my lord, in that case, Constitution Scheduled Caste Amendment Act 2/2021 enacted.
Appearing for, sir?
Well, I am appearing for 701/10 petition.
That's all right, but we'll not deal with, we are not going to answer, the validity of each individual act here. This is a challenge to the validity, the correctness of Chinaya is what is in question before us.
That will have a great, it will have a direct bearing on it. That will have a direct bearing on it.
Sorry?
Lord, so far Tamil Nadu petitions are concerned, my lord, my learned friends are arguing the writ petitions, my lord. Those petitions were sought to be transferred here and lordship has heard this matter.
So we will send them back.
Yes.
We'll send them back to the High Court.
Yes, my lord. That's what we have said, my lord.
Yes, we'll have to send these back to the High Court.
The act was passed.
When the Scheduled Caste Amendment Act actually passed with the similarly placed communities in the same caste, 7 caste for Arundhati by Tamil Nadu Assembly, another 7 caste Devendra Ullarar by the Parliament, my lord. Itself shows that the state government has no power, my lord. That's my point.
I'd like to appear for an intervener. My lords, I have already placed my written submission.
Please consider the written
But my lords, there is only one submission that I wish to bring to your lordship's notice, just 1 minute on that. My lords, I wish to submit that the list which is there under 341 is not merely a list of identification. With great respect, my lords, the term that they will be deemed to be scheduled caste for the purposes of the constitution, my lords, is actually a conferment of an identity, which, my lords, has been conferred through the mechanism of a presidential order. Once that happens, my lords, all rights, privileges, etc., that are flowing under the constitution would be available to them as a class.
Absolutely, no difficulty,
My lords,
correct.
it's a constitutional class.
That's the argument which everybody has made on this side.
My lords, only one aspect, my lords, I'm trying to pitch it a little higher than the mere fact that it's a list of identification, and that this can be then bifurcated. My lords,
So emphasizing for the purposes of the constitution. So every benefit which inures to the SC.
then everything applies to them en masse, my lords, equally. It can't be, my lords, that a particular, because they lose, my lords, with great
All right,
respect,
consider.
they lose their independent, distinct, my lords, identity. They become identified as my lords, entity under 341. My lords, that's the submission I made in that
Thank
written
you.
submissions.
Yes.
My lords, I
Yes,
declare.
Mr. Advocate. Yes, Mr. Advocate General. Fine.
Grateful, man. My lord, just two things which have been brought up by the other side in the arguments. I'll briefly touch, my lord. Your lordships have heard a lot on these issues. My lord, first, of course, is, my lord, that it is a homogeneous class because they are all born together, my lord, which factually and legally would be incorrect. Because the inclusion in the first order in 1950 may be a contemporaneous birth, my lord, but subsequently the addition deletion by the parliament ensures that any other caste can be brought onto the list under 341 at a different time. So most certainly, my lord, being born in the list together will not give them a homogeneity which the other side seeks to plead, my lord. I'm just cutting it very short, my lord. Now, my lord, the issue is, my lord, then regarding, my lord, the presence of the word tribal in both 341 and 342, my lord. And your lordship had correctly pointed out, my lord, though I noted it on that time, that some castes may have people who belong to a tribe and some may be non-tribal scheduled castes. So therefore, my lord, both have been included and whatever is relevant and whichever defines the caste more can be brought into play, my lord. That is my short submission. Your lordship may have already given the gist of it during the rebuttal, my lord, to them. Then, my lord, the status of word deemed, my lord. Now, my lord, I had again thought of it last night, my lord. In my submission, the word deemed is very clear because, as your lordships pointed out, that by mere inclusion in the list, your caste birthmark does not get obliterated. And there is a possibility that tomorrow you may be excluded from the list. So therefore, your caste, which is by birth, will never change. But your deemed status of a scheduled caste, for the purposes of benefits under the Constitution, can change. So you cannot permanently designate somebody as a scheduled caste under the Constitution. That is my humble submission. The status of scheduled caste under the Constitution is not permanent. And as long as that caste exists on the list under 341, a deemed status gets attached to it, which can be removed the moment the caste is out. That is what at least I could, my lord, gather in my research, my lord. Then, my lord, an issue which has engaged your lordships is regarding class and caste, my lord. The question had fallen from your lordships, my lord. The paragraphs, my lord, from Indira Sahni, my lord, which have been read, my lord, there's no need to repeat them. Your lordships have extensively looked into it. Now, there are those other paragraphs, my lord, in Indira Sahni.
But the argument is that Indira Sahni, a caste, they say could be a class in the context of the socially and educationally backward classes.
That's right, my lord.
So that if a particular caste satisfies the indicia of social backwardness,
that's right,
it can become a socially and educationally backward class.
Quite right.
Argument is that this will not hold true, or this will hold true with a difference in the case of the scheduled caste, because a scheduled caste does not have to satisfy the indicia of social backwardness.
Quite right.
Any caste, once it is designated as a scheduled caste, is presumed to have the indicia of social backwardness, because there's a pre-existing inquiry
That's
which
right.
takes place.
That's right.
Therefore, they said that, look, unlike the backward classes, the entirety of the grouping of scheduled castes is one homogeneous group. That is the argument.
That is their argument, my lord. But what your lordships have seen, my lord, that a class is not necessarily defined by a caste. A backward class of people may have to be identified with strong reference to their caste, but merely possessing a caste will not classify them as backward. On the reverse, my lord, a scheduled caste, there is a presumption of backwardness already.
So but therefore, the scheduled castes are a class.
My lord, yes. Scheduled
But
castes are a class.
Is an individual scheduled caste can be equated with a caste,
My lord,
with a class.
Yes. So therefore, the ingredients of backwardness would have to be satisfied still. The relative backwardness, which we are urging under 16.4. That's right.
You do not have to satisfy the indicia of backwardness at all.
Only for the purposes of most backward within the backward.
No, but before we reach that question,
that's right.
The argument really is that once you're a scheduled caste, you are presumed to satisfy the indicia of backwardness.
That's right.
Therefore, the entirety of the grouping of scheduled castes constitutes one class.
Please,
and how can there be a class within a class, therefore? That is the argument.
That is the argument. But what we are dealing with, my lord, in the present matter, is a class within a class only. As your lordships have said it, it is forward backward versus backward backward. Let us take it like that, my lord.
I'm not sure whether, a class within a class is what 16.4 permits.
Lord, that's what I'll just come to in half a minute. Lord, now, as long as the ingredients of quantifiable data of non-representation in the services is met, the state can make a special provision of reservation for that particular class.
Provided it is a class.
Provided it is a class. So therefore, the creation of a class.
And how can you then create one caste as a class?
Not caste as a class, my lord. Not caste as a class. The criteria would only be backwardness. Therefore, I'm saying under 16.4, unlike 15.4.
But every entry in the presidential list satisfies the indicia of backwardness.
That's true.
So there is no question of then saying that it becomes a class because it satisfies the indicia of backwardness. Everybody has the indicia of backwardness, and therefore everybody is together, bunched together as a class.
Quite right, my lord. My lord, if we read 15.4 and 16.4, my lord, just before I come to that, I've given, my lord, 5D, my lord, volume. Your lordship may only refer to 3 judgments, my lord. 2 of the vintage of 1960s, and the other is of 1994, my lord. I'll just read two paragraphs I want to refer to, my lord. 5D, if your lordships can kindly have a look, my lord. First judgment is, my lord, Action Committee on issue of caste certificate versus Union, 94-5 SEC 244. Kindly have para 3, my lord, of this judgment. I'll give the paragraphs, my lord. They can be read. That is on 341, so therefore I'm not dwelling much on it.
What is the citation of Action Committee?
Action Committee citation is, my lord, 1994, volume 5, SCC page 244, my lord.
At para 33, at para 3.
Para 3 and para 16, my lord.
Let's see that. No, there's nothing here really.
No, this is only regarding the power of the parliament. Therefore, my lord.
Para 16?
Para 16 is, my lord, we may add considerations for specifying a particular caste or tribe or class for inclusion in the list of scheduled castes. That's right. We may add that considerations for specifying a particular caste or tribe or class for inclusion in the list of scheduled castes / scheduled tribes or backward classes in a given state would depend on the nature and extent of disadvantages and social hardships suffered by that caste, tribe or class in that state, which may be totally non-est in another state to which the person belonging thereto may migrate.
Migration.
That's right. So they say coincidentally, it may be that a caste or a tribe bearing the same nomenclature is specified in two states, but the considerations on the basis of which they have been specified may be totally different. So same caste may occur in two states, but the reason of inclusion may be different. So, as therefore, merely because a given caste is specified in state A as scheduled caste does not necessarily mean that if there be another caste bearing the same nomenclature in the other state, the person belonging to the former would be entitled to the rights, privileges, and benefits admissible to a member of the scheduled caste of the latter state for the purposes of this constitution. So then, my lord, Dr. Ambedkar's, my lord, quote is there. My lord may read it, my lord. I'm not wasting your lordship's time. Second judgment, my lord, in which this class and caste difference is highlighted, my lord. Your lordship would see running page 19 onwards. I'm only pointing to para 14 of the second judgment.
What is the citation? Citation
is, my lord, AIR 1964, Supreme Court 1823, my lord.
No, this is just Ahmadi judgment. No?
R. Chitralekha, my lord.
R. Chitralekha. AIR 64?
1964, AIR Supreme Court, page 1823, my lord.
Para?
Starts from page 19 onwards, my lord. And I'm referring to para 14 of the same. Which would occur on page 27 of this compilation.
Yes.
Lastly, it is contended that though the High Court did not quash the order of the government embodied in Exhibit C, it held that it was not a perfect classification and also indicated its mind that the government should have adopted the caste test as well as the residence test in making the classification. If the observations of the learned judge, the arguments proceeds are not corrected, the state may be bound by such observations in the manner when it finally prescribes the criteria for ascertaining the backward class under 15.4.
Let's go ahead a little bit. Let's go on the next page. आगे जाइए.
Lord, may come to the next page, not second line. It is therefore manifest.
Yes.
It is therefore manifest that the government, as a temporary measure, pending an elaborate study, has to take into consideration only the economic condition and occupation of the family concerned as the criteria for backward classes within the meaning of 15.4 of the Constitution. The order does not take into consideration the caste of an applicant as one of the criteria for backwardness. Learned Counsel does not attack the validity of the said order, but in the High Court, conflicting arguments were advanced in support of the order as well as against it. The High Court heavily relied upon the decision of this court in M.R. Balaji and came to the conclusion that the scheme adopted by the state was
Go
very
ahead, actually, we
imperfect.
can skip a little bit. And what does our court hold? What does our court hold here?
Yes, my lord. My lord, then your lordship would see, it was also observed that the decision of Balaji says that caste basis is undoubtedly a relevant, nay an important basis in determining of classes of backward Hindus, but it should not be made the sole basis. It concludes that a part of the discussion with the following observation, but I earnestly hope that soon the state will make some more appropriate classification test. Its bona fides should be, lest its bona fides should be questioned. So therefore, my lord, the learned counsel contends that these observations are not supported by the decision of Balaji, that they were in conflict with the observations made therein. We shall therefore consider the exact scope of observations in the said decision. There's 68% of the seats, and this is, my lord, on merits. Your lordship may come to the next page, my lord, last 6 lines of this paragraph. Besides, if the caste of the group of citizens was made the sole basis for determining the social backwardness of the said group, that test would inevitably break down in relation to many sections of Indian society which do not recognize castes in the conventional sense known to Hindu society. That is why we think that though castes in relation to Hindus may be a relevant factor to consider in determining the social backwardness of the groups or classes of citizens, it cannot be made the sole or the dominant test in this behalf. So therefore, my lord, class is different from caste. Caste can be one of the factors, but not the sole determining factor, my lord. And this is again, my lord, in para 21, my lord, 20 and 21. On page 31, may I, my lord? This interpretation will carry out the intention of the Constitution expressed in the aforesaid articles. It helps the really backward classes instead of promoting the interests of individuals or groups who they belong to a particular caste, a majority whereof is socially and educationally backward, really belong to a class which is socially and educationally advanced. To illustrate, take a caste in a state where there is numerically the largest therein. It may be that though a majority of the people in that caste are socially and educationally backward, and the effective minority may be socially and educationally far more advanced than the other small subcaste, the total number of which is far less than the said minority, if we interpret the expression classes as castes, the object of the Constitution will be frustrated, and the people who do not deserve any advantageous aid may get it to the exclusion of those who really deserve it. This anomaly will not arise if, without equating caste with class, caste is taken as only one of the considerations to ascertain whether a person belongs to a backward class or not. On the other hand, if the entire subcaste by and large is backward, it may be included in the scheduled caste by following the appropriate procedure laid down by the Constitution. They make it very clear way back in 64.
Now, after Indra Swani.
That's right. So therefore, backwardness is a totally separate criteria which will determine the carving out of a class, and caste will be one of the determining factors. 21 also says, so my lord, we do not intend to lay down any inflexible rule for the government to follow. The laying down of the criteria for ascertainment of social and educational backwardness not proceeds on the same lines. Let me not, my lord, waste your lordship's time. My lord, now the other thing, my lord, on similar lines is, my lord, state of Andhra Pradesh versus AP Sagar, my lord, 1968 AIR Supreme Court. Page 1379, my lord. Starts from page 48. I am referring to para 6 only, my lord. Which is on page 51. The list prepared on the basis of reservations for socially and educationally backward classes is indisputably a list community-wise. On behalf of the petitioners, it was contended in the High Court that the government of Andhra Pradesh has adopted the same list of backwardness of classes, which was struck down by the High Court in P. Sukhdev's case with some slight modifications, and the new list also having made reservation in favor of the castes and not classes. It infringed the guarantee under Article 15(1). On behalf of the state, it was urged that the caste is one of the relevant tests in determining backwardness and cannot be ignored in determining the socially and educationally backward classes. If a group has been classified as backward on other relevant considerations, the classification is not liable to be challenged as invalid on the ground that for the purpose of classifying, the designation of a caste is given. The High Court held that the earlier GO was so and so. Then next paragraph, note, in the context in which it occurs, the expression class means a homogeneous section of people grouped together because of certain likeness or common traits and who are identifiable by some common attributes like status, rank, occupation, residence in a locality, race, religion, and the like. In determining whether a particular section forms a class, caste cannot be ignored altogether. But in determining of a class, a test solely based upon caste or community cannot also be accepted. Now, this in a way answers your lordship's query. By clause 1 of Article 15 prohibits the state from discriminating. This your lordship would read. Now, my lord, last, my lord, because it's intriguing me, and if your lordships are going to go into that question, can your lordship just have 15(4) and 16(4) with me, my lord? It'll take 2 minutes. The language, my lord, employed in these articles have it. Formula. Nothing in this article or in clause 2 of Article 29 shall prevent the state from making. But this is pretty much common apart from the fact that the earlier words are missing. Any special provision for the advancement of. So, Mulad, in 15(4) and 16(4), any special provision is provided, Mulad. Till here, there is a commonality of any socially and educationally backward classes of citizens or for the scheduled castes and the scheduled tribes. Now, my lord, what we need to just see here is number one, my lord, just a slight take on what your lordship said, given the qualification to the word any. Because there is no comma after citizens, we will have to read any for all the three classes. That is my humble submission. It says any socially and educationally backward classes or citizen or for the scheduled castes and scheduled tribes. So the choice is given, my lord, to the state to choose any of these categories for the conferring of
No, but you know, actually it's like this. No, it may not be correct.
So, my lord, may examine.
To break it down, it will be like this. Nothing in this article or in clause 2 of Article 29 shall prevent the state from making any special provision. We'll put a colon.
That's right.
A, for the advancement of any socially and educationally backward class of citizens, semicolon, or B, for the scheduled castes and scheduled tribes. Because if the for the advancement of any were to apply to the scheduled castes and scheduled tribes also, then it would read like any special provision for the advancement of colon.
It would come here, my lord.
Any socially and educationally backward class of citizens, or for making any special provision for the advancement of.
It has to be advancement of colon.
For the scheduled castes and scheduled tribes.
My lords would kindly see if the colon comes, as your lordships are suggesting,
yes,
after advancement of would be more appropriate because advancement is a common objective.
Yes.
Advancement is not limited only to socially and education.
But then what? No. Then how will the clause be read? For the advancement of for the scheduled caste and
scheduled caste.
You can't have a for twice. You can't have a for twice. So obviously that earlier for indicates that there are two fors. One for is for the advancement of any socially and educationally backward class of citizens, and the second or for the scheduled caste and scheduled tribes.
Mulad is saying if it comes after provision.
Right, because there are two fors, which shows that there are two subjects there. One, the first subject is for the advancement of any socially and educationally backward classes of citizens. And the second for is for the scheduled caste. So any special provision for the scheduled caste and scheduled
That
caste.
interpretation which your lordships are suggesting would mean that the word advancement of are not being used for scheduled caste.
No.
Because then your lordships are attaching it only to socially and educationally
Right,
backward.
any special provision for the scheduled
That's
caste.
what I'm saying. So, my lord, advancement of is common to both, according
So
to my
any,
humble.
no, what is common is any special provision. And after any special provision applies to the first part for the SEBCs as well as for the special scheduled caste and scheduled tribes.
Lord may examine it, but I think, my lord, the advancement of is also common to both. Advancement of is guaranteed to
Can't
both
be,
these
because then the for will be repeated in the sentence twice, which is
No,
not
where for is
grammatically
not
incorrect.
repeated of.
For is repeated
Of
twice.
any socially and educationally
So
backward class of
the
citizens.
common feature is nothing in this article or in clause 2 of article 29
Please, my lord.
shall prevent the state from making any special provision. That is common. Special provision for what? First, for the advancement of any socially and educational backward classes of citizens, or the second is for the scheduled castes and
Then the
scheduled tribes.
purposive interpretation will go, my lord.
No, but
Then
then
the purposive
Indra Sani also
interpretation-
says, Indra Sani also says that for scheduled caste, educational backward is not a necessity.
Not
No, my lord, only the backwardness, all right, but advancement is the purpose of this article.
No,
If
but
we
the
take advancement away from
The
scheduled
moment you
caste-
say special provision,
it is for
it's for advancement.
Very well, my lord. That was what comes to
Yes.
my mind. Why? Because when I read 16.4, my lord, your lordship would now see 16.4's language. Nothing in this article shall prevent the state from making any provision for. My lord, here, instead of advancement, it is limited only to reservation.
Right.
It says provision for the reservation of. Then, my lord, appointments or posts in favor of. Now comes the category, my lord. Any backward class of citizens. I stop here, my lord. Now, instead of what is given above, if your lordship would see the difference there is that the word used is the scheduled castes and the scheduled tribes. It had fallen from your lordships. Why the word the? So in 15.4, the benefit can be given to a category identifying it as the scheduled caste which deserves the benefit. While under 16.4, the scheduled castes and scheduled tribes have not been distinguished from backward classes in the manner of making a class which is entitled to these benefits. Lord, may kindly see again, my lord. The language of 15.4 is or for the scheduled castes and the scheduled tribes.
Right.
So there your lordships had said by the word the is coming is because they want to give it to a particular caste. But in 16.4, the discretion of the state has been enhanced and expanded.
In favor of any backward.
Any backward class where they say that the identification is your problem.
But the question is whether the scheduled castes in the entirety are a backward class of citizens, or can you further micro-classify it so as to include every caste there as a backward class of citizens?
Lord, can't be, because why can't be under
Their argument is the SCs as an entire conglomeration of class is the backward class.
Yes, so therefore, Lord, under 16.
And every entry within that backward class cannot be again classified as a backward class.
That is their argument, my lord.
Yes.
But therefore, the collection and, my lord, implementation of this clause based upon the data, if your lordship would see now after what I've read, which in the opinion of the state is not adequately represented in the services under the state. If backwardness is presumed in the favor of scheduled castes, then they don't even need data. Then they don't even need the state to form an opinion.
You still require data on adequate
Other
representation.
classes, yes. Even adequate representation.
Adequacy of representation, you require data for the
That's
scheduled
right.
caste.
So
also.
therefore, the check
But you
and
don't
balance.
require quantifiable data on backwardness for the scheduled caste.
Right, right. So therefore, the check and balance is there in Article 16.4 itself. But the discretion in what argument I'm trying to make is under 16.4, the Constitution has given a far larger discretion to the state because it does not lay down the fetters that it has to be a scheduled caste or a scheduled tribe. It can be any backward class. And my lord, we are aware that the state has made in the past special provisions for areas which have been ravaged by floods, for Kargil victims, in the appointments of the state government to say that they are disadvantaged. But suppose a particular village is hit by a pandemic, my lord, and most bread earners in that village die. The state in its opinion can say they are disadvantaged. They need, my lord, promotion as far as the state services are concerned. So people belonging to a particular class within that area being treated as disadvantaged will be given special provisions. So the power is much vaster,
Right.
much bigger, much larger.
All right. Thank you, Mr.
Deeply
Abhinav.
2 minutes was I'm taking. First, two submissions. Plus, firstly, that insofar as your lordship's prima facie view is that backwardness cannot be gone into only inadequate representation. Well, may I just try on that just 1 minute? Because Indra Sani on 2 levels tries to define backwardness. First analysis is to identify you as a backward. And because then the paras which were read out to your lordships is within that whoever has been identified as backward, caste being one of the factors, you define who's more backward and less backward. I am saying, Manoj, first analysis of identification of backward surely will not apply to SC/ST because they are presumed under the constitution to be backward by being there in 341. But that second analysis equally applies to Manoj SC/STs. That's my respectful submission. If your lordships will read.
The more backward and the.
That's right. So it's on both the counts of more backward and inadequate representation, reading from Indra Sani. That's first submission. Second, Manoj, they are accepting that under 16(4) the power is to grant reservation, not to grant at all, or the degrees of grant. I can grant 5% to SCs, I can grant 10%, I can grant 15%. Plus, surely if I have the bigger power to grant, not to grant, and the extent to grant, then the smaller power within it, to whether can I distribute it amongst different groups, should be included in that. It can't be it's all or nothing. If I have the larger power, I must necessarily have the smaller power. That's the second submission. And finally, your lordships had asked in the morning, what happened to the Usha Mehra committee? Because on that, really speaking, the answer is in one word, nothing. Because it was sent to the government, and this is the answer from the concerned minister in the parliament. And they are saying they're still contemplating as of 2021. I've also checked the recent status. This can also be put up on the screen if it is. This is the answer in Parliament on 2021. The states of AP and Telangana, while forwarding a copy of the resolution passed by the Assembly, have requested for subcategorization of scheduled caste. A national conference to examine was headed by Justice Usha Mehra had been set up. In its report of 2008, had recommended amendment of 341 of the Constitution to provide for subcategorization and de-subcategorization of scheduled caste. Government has decided to seek views of the major stakeholders, the state governments, the UTs, on recommendation of NC, SC, SC. The state UTs were last reminded on 9/12/2019. Moreover, the matter is presently sub judice in the Supreme Court. So that's where things stand. Nothing happened. There was a private members bill moved in 2018, but that was on OBC subcategorization. So that's my understanding. I'm grateful.
Thank you. Yes. Yes.
There's a problem, Manoj, on the submission that this is homogeneous. And we'll assume for the purpose of argument it is homogeneous. And naturally, distribution has to be proportionately. It's as simple as that. If you say that scheduled castes are distinguished from backwards on the grounds of untouchability, then each is untouchable. And then on the basis of population, you'll have to distribute, otherwise it will be violative of 14. It's an argument, Malaj, that defeats itself.
Yes.
You can't say, Malaj, that it is homogeneous. Everybody has the same attribute of backwardness. Therefore, everybody must be treated equally. Then where does the state get the power to give X to Y and Y to somebody else? This percentage to him and that percentage to somebody else? Ex facie, it is bad. 2, Malaj, it is treated as a class for the purposes of identification. The concept of class is in the context of identification, not for the purposes of granting representation in services.
But then 16(4) also uses the word class.
Correct. Well, therefore, class in the context of identification under 341, class for the purposes of reservation under 16(4) are two different concepts constitutionally. If you say it is identified as a class, then you assume that there is no difference between each one of them that is identified. If you assume that, then you can't give representation to one and not to the other. If you don't assume that, and each one is a class, either way. I hope I made myself clear, Manas.
Yes.
You can't have it both ways. So, Manas, when in 341 you identify different categories of castes in one identified schedule. It identifies the schedule caste, that is caste in the schedule. That class is subsumed, the castes are subsumed in class, and each one is a class on its own. It has to be. And therefore, Manas, is included, and a separate reservation can be given. That's the only way, Manas. Otherwise, the argument that I am being deprived, but you're not being deprived if you argue that this is homogeneous and everybody is the same. The argument means it's untouchability. Everybody is attributed with untouchability. But if that's the attribute, you can't discriminate. So, Manas, therefore, it is contrary to very submissions they have made. Point number 3, Manas. 16.1, if you notice, says there shall be equality of opportunities for all citizens in matters relating to employment. These are also citizens. There should be equality of opportunity. Then 16.4 says, nothing in this article shall prevent the state from making any provision. In other words, even if you say that they belong to the same class, nothing prevents you to give a special treatment if they are inadequately represented. Either you fall under 16.1, it'll be you're entitled.
Yes.
If you don't fall under 16.1, 16.4 gives you ample power to do what you like as long as any backward class not adequately represented. Each caste is a class for the simple reason that it represents a certain attribute of backwardness, a certain separate attribute of backwardness in the context of its own special position in societal hierarchy in the particular state where it is present. And that class, therefore, is entitled, as a matter of law, constitutional law, to special representation, provided they are not adequately represented. And then, Manas, the last point is, and I won't say anything more, I've given to your lordships those passages, which is in note 1L. Note 1L are all the paragraphs of Indira Sahni, Manas, that refers to all this. Really, there is nothing more that I wish to say, Manas. That's all I wanted to. That's all.
Was answered in 16.4. What is followed, my Lord the Chief Justice, minutes? I'll just take 2 minutes. Let's take the sequitur of saying that when 16.4 says any backward class, then you take scheduled caste as a category by itself. That's the argument. So scheduled caste is one category, scheduled tribe and SCBC. Now then let's see the sequitur of that. Then it means that the discretion given to the state is in favor of any scheduled caste or scheduled tribe or SCBC as a conglomerate. It renders the subsequent words, namely number 1, which is inadequately represented. So what will happen is that the state finds that scheduled caste on an entirety has got 25%. Why? Because 2 castes out of that have got all of them. But it can't do anything. It can't do anything for any of the other castes because the scheduled caste as a category is adequately represented. Therefore, if this argument is accepted that class means scheduled caste as a whole, then merely because 2%, 2 or 3 castes in the scheduled caste fill up the entire lot, nothing can be done by the state millets. Then as well from my Lord Justice Gawai earlier, you have to read it with the words adequate, not adequately represented. That has to mean it can't be, scheduled caste can't be a class in itself, millets.
Right.
In the sense of one conglomerate. Otherwise, where is the discretion, millets? I ask myself, where is the discretion? The government finds, the state finds that the scheduled caste in entirety have got 25%. That means they are helpless. The 3 crucial words are any, which, opinion, and not adequately represented, which show the discretion being given. Point number 1. Point number 2, millets. Indra Sani also refers to this, Malad, this aspect. I'll just note the parameter 781 where they say, we may state that for the purpose of the discussion, we keep aside scheduled tribes and castes, since they are admittedly included within backward classes. So scheduled castes and then the rationale given thereafter, which I read earlier, Malad, squarely applies here also. Otherwise, the whole meaning becomes redundant, Malad. One caste within that is not being deleted under 341. They get everything and the state is helpless. That would result in a perversity, is my most respectful submission number. Then, Malad, a submission was made, Malad, that Ashok Thakur has said creamy layer, etc. applies. Creamy layer is not a concept which can be applied here. That, Malad, is, in my written submission, it's there. Para 183 and 186 of Ashok Thakur say so on the premise that creamy layer is not a principle of equality, which Jarnail Singh has clarified completely, Malad. Jarnail Singh says it is a facet of Article 14, and therefore that part of Malad's article, Ashok Thakur is no longer relevant. Lastly, Malad, I'll put a short note, Malad. I have 2-3 other things to say on this. Give a short note. But if this is accepted, then the whole discretion being given here under 16.4 is completely lost.
Thank you, Mr. Ansaria.
Just 2 minutes. So far as Arun Khatiyas is concerned, my lord, my learned friends have said, my lord, they are represented. Now, the Janardhan committee has found, my lord, only in category D, my lord, as a matter of fact, they are represented which are excavating work. In all the other cases, my lord, 2%, 3%, they are the 15% population, my lord, and they are there, my lord. Your lordships are not going into it, but since my learned friends raised this issue, my lord, the transport.
We are not going into that. We are not going to go into the
Very
individual.
well,
Chaman Lal ji.
No, with respect only one thing, my lord. We have data relating to backwardness, this backlog, my lord. More than 50% posts are vacant. We have data could be placement. Because they say that
issue here at all, not necessary.
So
Thank you, Dr. Chauhan.
Purpose, not for.
There's an article in 5D, Mulad, at the end of it, which gives definitions to all these very comprehensively, but it has no judicial sanction, so I didn't quote it. But your lordship may, for reference, have a look.
Thank you. The last part, the most pleasant part, to thank all of you for such erudite arguments on both sides. Thank you.
My lords, extremely grateful, my lords, for the opportunity.
My lord, I would like to submit only one thing, my lord.
Yes.
The Punjab Act enacted under Article 245, 246, the Punjab Act of 2006. While enacting the Act with respect to scheduled castes, they have to obtain the consultation with the NCSA as provided under Article Clause 9 of 338,
yes.
which they have not obtained the consultation.
All
Therefore, that is unconstitutional act, my lord.
Already.
So just one suggestion, Mulad.
Chaman ji, आपने जो कहना है वो आप लिखित स्वरूप में कह दीजिएगा.
We have suffered
1 point, Millard. 1 point, Millard.
untouchability. We are the person,
Not that.
untouchability.
Grateful. Extremely grateful, my lords.
Rajpal Gupta.
5-judge bench. 5-judge bench. Who is appearing in the 5-judge? The curative in the that is rendered infructuous as a result of the judgment in Navtej Johar. So we'll say that the curative petition has been rendered infructuous by the judgment which has been delivered by this court in Navtej Singh Johar.
One submission, Millard, the sufferer's voice has to be recognized by the.
My lords.